Order the August 17th meeting of the Planning Commission, and we'll begin with roll call.
Chair Spears.
Present.
Vice Chair Hutt.
Here.
Commissioners Desai.
Here.
Fireman Hunt. And
Here.
Pevsner. Hutt. Well, I have Hutt already. And Pevsner.
And at this point, we will entertain a motion to approve the agenda, or any modifications thereof.
I'll make that motion.
Second?
All those in favor?
Aye.
Aye.
Okay, passes. And now we'll look at the approval of the minutes of the meeting of August 3rd. Are there any additions or corrections?
They look good to me.
Look good to me.
Same here.
Okay, well, I'll entertain a motion to approve.
I'll make a motion to approve the minutes.
Second?
All those in favor?
Aye.
Aye.
Okay. At this time, any person may come forward and address the Planning Commission concerning any item that is not listed on the agenda. Hang on, Charlie, I gotta finish my thing. The Planning Commission welcomes your participation and input. When addressing the Planning Commission, please begin by stating your name and address for the record. Please limit your comment to no more than 4 minutes in order to provide for orderly and a timely meeting. Come on, Charlie, let's have it.
Charlie Kissinger, 677 Brookside Lane. This isn't directed to our city water department or our street department, who do an amazing job, and this is only sort of directed towards the planning services department. But all my questions have, I think, since been answered. And I'm the only one who the neighbors will call because I'll come down here. Most neighbors don't want to come down here. I don't know why. I woke up on Monday morning to a phone call saying Vista Circle is blocked at both ends. And I go, how can Vista Circle be blocked? We weren't notified. And there was road closed signs. Okay. There was also a bobcat, very large bobcat in front of my house, a dump truck, workers, porta potties being delivered, and workers' trucks. I come down to city and I say, how can this be? Nobody was notified. And the answer I got about 3 or 4 times, which I wasn't happy with, was because we can. So this, as opposed, this, Mr. Harbidi, and I hope he's not listening, is a process question. How can we get a road closed for Monday, Tuesday, Wednesday, Thursday, a main road where people would have to back up going both ways, people can't turn around, and nobody on the block is notified?
Can I ask a clarifying question?
Yes.
Was this a municipal project?
No.
Or this was a private?
This is a private project.
Okay.
And that's why I say my questions have been answered, mainly by James Carlson, and I think the project is probably on hold at the moment. But again, I came down here Monday morning to say, how can this be? I got no satisfactory answer. And then I got busy Monday, Tuesday, and somebody called and said the road's still closed. With right at Oakdale, there was a road closed sign, and further on the other side, road closed. Again Wednesday and again Thursday. And I think James got back Thursday afternoon, and things seemed to change.
I'm sure we'll get clarification from staff, but I want you to be aware that when we look at projects in the canyon, there's a specific checklist of when they can deliver and what kinds of other things. We're familiar with that. So
well, that's my problem. Something didn't get checked.
Okay.
Because the road was totally, I mean, this wasn't like one lane blocked. This was completely closed with trucks, workers, porta potties, digging, tractors. And again, my question is, let's revise that checklist, and if somebody is going to get a road closed sign, I think we need to be notified. Because we had the driveways blocked, all sorts of stuff.
Okay.
Yes. That's all I got to say.
That's
Thank you.
just to add a little bit more clarification. Code enforcement was notified. We did contact Public Works to see if there was an encroachment permit that was issued for that work. This was at a private residence, and there was not. And eventually we went out inside of them and told them to stop. And then we left it in the hands of our Public Works crew.
Okay.
So it wasn't someone working on the road or something, it's
No,
just some
it was
people
a
working on a private
private project.
property. and
Private
they
property,
just
yeah.
Decided they could stop.
And
Stop
it,
the road.
and I assume that if they would have applied for an encroachment permit, then the city would have notified
That would be
the residents, and you guys would have known that that was gonna happen.
Why is it seems like somebody should go and check whether they're
Encroaching. Yeah,
Yeah, but
the city hall doesn't have control over all the contractors in town, so so actually, Charlie, you played a very important role, because we rely on the citizens to help us know everything that's going on in town.
I guess my problem is when I came down Monday, nothing was really done for 4 days. That's, I guess, where, and again, I'm not trying to blame anybody. I just, as Mr. Horby is process. Thank you.
Okay, and thanks for coming in and telling us, Charlie. Is there- Okay. Is there anyone else who wishes to address the planning commission at this time?
Hi, my name is Michael Kuroda. We live at 434 Teresa Lane. And I was wondering if we can bring up the topic of the water moratorium, because we own the property at 370 Grove Street, and we'd like to build a property there, but with the water moratorium, we can't get a water meter or, do a building permit. And yeah, we've grown up in this town, and we just want to, me and my wife want to build a house and do a house here. So it'd be a personal house, not like a development or anything like that.
Yeah, it wasn't us.
Not you guys.
Yeah, that's a council resolution enactment under their authority under the water code. And the way that moratorium works is it won't be lifted until the groundwater level is restored sufficiently so that the city can pump its adjudicated amount of water. So it has to come up above the 500-foot level.
Okay.
And that might, if we get good rain, the water department has advised that that could be a year or two. So we don't think it's forever, but that's what the moratorium says right now, because right now the city still cannot pump its own groundwater. We're still importing water, pouring it into the ground to filter it, and then pumping the water that we paid for. It's very expensive. So that's why it's so important to get the groundwater restored. It really depleted a lot during this severe drought, and we hope we get a lot more rain in the next couple of years.
Okay. Thank you.
Hold on, just a follow-up question for you. You said your property's on Grove?
Yeah, the 370, there's an empty lot.
It's been an empty lot?
Originally, I
Was
believe
there
it
ever
was
a
like,
a house on the property?
yeah, there was a guy who owned the house, and it was a pretty big lot, so they split it. And so then the person above us had the house where the house was
Meter.
located, so he has the water meter. And then we had like the yard, and then, yeah, now we can't build.
There's
I
no
got it.
existing
So
meter.
it was split?
Right.
Yeah.
Okay.
Yeah,
Yeah,
that's
so-
one of the exceptions to the water moratorium, is if a property already had a water service connection, so technically you're an existing client
Yeah.
of the water company, then you could construct something, and even if there was nothing there, or even if it had been vacant for a really long time, but you have to actually have had the water service connection on the legal lot in order to be able to get a new connection and build something new.
Okay, so I could take it up with like the planning department sometime.
Well, you can. I mean, you can go there and see if you can establish that there's a water service connection that's on your legal lot. But if there was only one and the lot was split and the other property got it, then you don't have it.
Yeah, I think that's what you're,
Yeah, I just didn't know if maybe you would like grandfather it in or something like that.
well,
We can take it.
Might be
I
worth-
can talk to him.
yeah,
Okay, I appreciate it. Thank you.
never hurts to ask.
And Terry, when the water level reaches the amount in the aquifer that can pump, the city council is going to remove the moratorium on its own?
It will.
So it's not an issue where people in town need to petition or anything like that?
No, the language in the moratorium is pretty clear that it's only until that happens. So we're waiting for that restoration of groundwater. And then the moratorium will be lifted.
There was a very informative presentation by the new city manager, 2 weeks ago, that was very helpful if you want to go back and look at it. I think it's posted somewhere. It's online, and it will be very helpful for you. Anyone else wish to address the Planning Commission? Okay, then we will move on to the public hearing section. We'll begin with the vacant residential property registration ordinance. We have a staff report.
And I have a PowerPoint presentation.
Boy.
And this is really to kind of inform people at home who are in watching, possibly watching. So the Planning Commission conducted a public hearing, or will be conducting a public hearing this evening to consider Municipal Code Text Amendment 17-05, which establishes a vacant residential property registration requirement. The Commission discussed the matter on 4 previous occasions going back to February and November of 2016, and more recently discussing the item in July and as late as just as recent as August 3rd. The intent of the ordinance is to address concerns regarding vacant residential properties. To date, we have identified 47 known vacant properties that are located in the city. Vacancies are perceived to disrupt the community fabric of the neighborhoods in which they exist, and the lack of activity and oversight often results in deferred maintenance of the buildings and landscaping, which become an attraction to vermin and wildlife and potentially cause depreciation of property values to surrounding homes in the neighborhood. And further, the lack of a local contact person has also made it very difficult to take corrective action on many of these properties, especially in times of the emergency or to correct public hazard, safety hazards, such as water leaks or felled trees and brush clearance. The objective of the Municipal Code Text Amendment is to protect the health and safety of residential neighborhoods through the registration requirement. The ordinance will also serve the property owner by providing immediate notification of a public safety hazard at that property. The owner registration is not considered a public record and therefore is not subject to public records request and is only will be authorized for city staff and public safety personnel in the event of an emergency and or maintenance code violations. The registration requirement of the draft ordinance requires the property owner to identify 3 points of contact that will be responsible for the property. The 3 points of contact will include the property owner, other responsible parties, and that could be a neighbor, and or a property management company. The status of a vacant residence is to be established by evidence of vacancy. So the ordinance has identified that if there was evidence of vacancy for a period of 60 consecutive days, that the property would be considered vacant. And also upon notification of that vacancy, the property owner or the authorized party will be required to register the property within 10 calendar days and shall pay an annual registration fee. In addition to filling out the property registration application, at the time of submittal, the property owner will be required to submit a property maintenance plan, and that would include general landscape maintenance, brush clearance, building maintenance to ensure that the existing exterior of the building is secure, free of pests, and maintained in a manner consistent with the neighborhood. And it also will also identify a maintenance plan for regular swimming pool maintenance if that is applicable to the property. Security requirements. The responsible parties for any real property subject to the registration requirement shall submit an emergency waiver to the city at the time of registration to authorize the police department to remove and or arrest all unauthorized persons from the property. And the emergency waiver will also allow the fire department, planning and building department, and or public safety personnel to access the property to respond to health and safety issues. Regarding the first bullet point that I just spoke of, our city attorney did express some concerns, and we can have a discussion about that when we go into the ordinance. Determination of fees, the city council will establish the annual registration fee, and any additional fees if additional inspections would be required. The average, which was determined, $251, was determined through the 31 cities, the supervisory districts, and 3 water districts, averaging the amount that is anticipated at $251. However, staff will continue to do a little bit more analysis, and we will determine what that fee is. It could probably be a little bit less in most cases, but we'll determine what the staff allocation and cost would be to recover inspections and taking in the application form. The alternatives before the commission this evening are as follows. You can recommend approval of Municipal Code Text Amendment 17-05 pursuant to Planning Commission Resolution 17-06. You can recommend approval with modifications, or you can continue the matter and provide further direction to staff. Staff recommends that the Planning Commission recommend approval to the City Council of Municipal Code Text Amendment 17-05, amending Title 8 of the Health and Safety Code, establishing Chapter 8.18, vacant residential property registration requirement. At this time, I'd like to move to our handout materials, and we'll review the red line draft of the Municipal Code Text Amendment, registration form, and emergency waiver form. So the red line of the Municipal Code Text Amendment is located in Exhibit B. We went through this in detail on August 3rd, and we did have some additional changes to the text. So a lot of the corrections were correcting the reference to chapter. I had it as capital C.
Mm-hmm.
We took those out and put them in lowercase. So you see that will occur throughout the document, as well as a reference to article, should have been chapter.
So one question I had was, and it doesn't look like it's something we changed, it was already here, but under 8.18.040 registration, there's a item 5 that says property owners who are on extended vacations have the option to register their property for security purposes at no fee. So is that a different registration? Are they registering for the same thing?
It would be the same registration form.
But no fee, because there's not going to be an inspection or anything?
Right.
Okay.
And this was something I believe the commission had an initial discussion, and we incorporated this language in there.
Okay.
But they would sign the waiver that would allow police and fire to access the property in the event of emergency.
And we can probably clarify that in here as well then.
Yeah, it probably would be helpful.
They'd be filling out everything. There's going to be no inspection and there's no
Yeah.
fee. It's just
No,
kind of
it's
like,
just-
in case something happens.
Yeah, so that they have, it's just
While you're gone.
essentially to provide contact people
Yeah,
in case something happens.
that makes sense. And is there anything there, I'm just trying to find loopholes here, but when we say extended vacations, do we need to define that? Or if I'm a absentee property owner and I can be on an extended vacation for 365 days, I don't know.
That's true. We may want to,
I don't know.
I'm just,
I don't think we're.
I'm just
I think we should.
what do we mean by that? Just like 61 days?
Well,
Or more.
somebody wants for 2 weeks. I think they can fill out the form if it
Yeah.
warms their heart.
Well, it's not considered vacant
Right, this is an optional thing, so I don't foresee it's a big issue. And if it becomes one, well, then we can, you know, if the police department finds that they're
Well,
turning into a
but also-
private security service
Yeah.
for people on vacation and we need to charge, you know, we can do
Yeah,
it. But I gotta think this is gonna happen every now and again, and it's not gonna be a big issue.
If they live above Grandview, they're in a high fire zone, and if they leave in July, August, September, or October, when we are, you know, have high brush area, it might be very helpful for the city to know that fact. It will be hard for the planning commission to promise behavior on the part of the police department in terms of, you know, whether they're gonna check the building or things like that. I think it would be more of convenience for the city to have access in the event that there's no one around, and the fact that the city would know maybe there's somebody that they can contact.
Maybe the word security is too strong. Maybe we could just say for information purposes or something. No, I mean, just, security it could almost sound like you're promising to provide security, whereas,
That's a good point, yeah.
you know, information just says you're letting someone know that they're not around, and
Yeah.
I think that might be more to the point, really.
Safety? I don't know.
Kind of like
Let's say
information. It's very
information.
general.
Yeah, I agree.
It makes no promises, you're just providing information.
Now, in the past, the city has taken, I mean, I'm old enough to remember where, you know, if you were on vacation, you could call it in and they would come by, but I don't think that's something that we can promise.
It isn't.
I think you're right about just, you know, in case, you know, there's a giant windstorm or a fire or, you know,
Mhm.
something happens. It's kind of handy to know that nobody's there.
Yeah.
So are we just following down through the pages, is that?
Right, if if anything stood out to you.
I have a typo on this page under 818.050.
Mhm.
A, it says form, in the last, under A, in the last, second to last line, it says form instead of from.
1-year form, oh, yeah.
One-year form. I know
Those
that
things that
problem
are
because I have
not
done that
caught
a
by
million
spell checkers,
times.
yeah.
Those things that spell check doesn't get. It says form the date of registration.
Good catch.
Very good catch.
You see it, Vincent, the
Yes.
last, yeah?
Mhm.
There are a couple of those in here that I will mention as we go through. I just like to say this looked good, I thought.
Yeah.
Yeah,
From,
I agree.
as we start. I didn't see a lot of issues with it personally.
Maybe this would be a good time to talk about the security requirement and the waiver form.
I'm just thinking out loud to suggest some explanatory language. The issue with the emergency waiver form and also the language in the ordinance, which
17.18.080B.
It's the provision that says that this form will authorize the police department to remove and/or arrest all unauthorized persons from the property. The problem with that is the city, California is probably the strongest tenants' rights
Right.
state in the country. And so someone can
Squat.
access, yeah, exactly, property, and if they've been there for more than 30 days, the city, no one has the right without a court order to remove that person. Now, if the property owner's there and they have security cameras, or let me rephrase that. If it's a vacant property and the property owner has an alarm system and security cameras can actually catch somebody that's visibly breaking and entering, that's different. And, you know, that would get called in, and of course the police can come and respond to something like that. But what we have here is someone saying, okay, my property's been vacant from my perspective for 60 days. I'm going to come in and register it, and now I'm going to turn around and sign this waiver and emergency form and serve it to the city and say, get rid of the people, the unauthorized people that are squatting in my house. And of course, we can't do that, and that's not what we mean, but it could be read broadly in that way. So my suggestion would be, in the ordinance itself, we need to put some disclaimer language that, and I haven't finished drafting it yet, but.
Can we just put a period after registration? Instead of saying even what the emergency
Yeah.
waiver does in the ordinance.
You don't even
then-
have to go there.
And then we can, because then the real issue is going to be dealt with in the form, right?
Yes, and in the form, I would suggest removing that language, and I know that's more of an administrative thing, but if we're at bare minimum, I would want an indemnity clause
Yeah.
in the form.
We
And
talked about
that's
that, I
easy
think,
to
last time,
put
too.
in there,
Yeah.
so.
I mean, in the form, I don't, I mean, we're not,
Yeah.
I don't think we're, like, we don't really want to write the form as a commission. We just want to give you advice about what
Right.
we think should be included. So you're suggesting that it just says they shall submit emerging waivers or put an emergency waiver to the city of Sierra Madre at the time of registration.
Period.
Period.
And then the
Just
following
leave it at
sentence
that.
is still okay, that the waiver
Will also allow.
will allow, get rid of the word also, allow the fire department, police department to access the property.
Have to add police department in there because it's not in that part of the sentence.
Right, that's a good point.
Right.
To allow the police department, fire department.
Code enforcement officer or public safety personnel.
Yeah, I would put code enforcement officer in there. Oh, they're already there.
Yeah, that
Okay.
Yeah.
police
Yeah.
department.
Oh, public safety personnel is police, so,
Well, we were looking at public safety personnel as also, maybe it's a utility company.
oh, I see. Okay, so
Or
call
the-
out specifically
Or the
police
Humane
then.
Society, say,
Sure,
or something.
okay.
You could also in the form have them warrant that the place is actually vacant.
Yes. Yeah. But we probably wouldn't, I hate to give someone false hopes.
Right.
By having that language in there that we will remove an unauthorized
Right,
person,
right.
but you'll indemnify us. As, you know, there are any number of people would say, I'm willing to do that. Heck, to have to go through the court system and get an
Oh,
off
yeah.
retainer costs me a lot more. I'd rather take my chances. So I would most likely
Leave that.
recommend that we
Yeah.
don't even mention that
Right.
we would do that.
Yes.
I
And
agree.
by not saying it doesn't mean that if we get called out because there's a break and enter in the process and the police go there, that doesn't mean they can't arrest those people and
I mean, if we leave in this language about respond to health and safety concerns,
sure.
Yeah, that's, I think
Yeah.
it's
kind of covers what we're
That's-
talking about.
does.
general enough in the code, and then
Yeah.
we can deal with those issues in specific if we want to in the form. And that's best left to staff and council and anyhow.
Yeah.
Should we change concerns to hazards to read to respond to health and safety hazards, such as stagnant water in swimming pools, etc.? Is it a concern or a hazard?
I think concerns is broader.
Yeah.
It concerns is broader. There could be legitimate concerns, issues, whatever you want the word, to which someone would later argue it didn't, it wasn't bad enough to become a hazard, so.
Well, I mean, like piles of mail out front and stuff is not really a hazard, but it is a concern.
It is a concern.
Yeah,
Right, especially to the neighbors.
Mm-hmm.
yeah. I have another question, going up to 8.18.070. 3. Real property subject to shall submit at time of registration a maintenance plan that includes building maintenance to ensure that all structures are secure. And the shall is
So-
just, copied from somewhere else.
So you want to change it to
The shall to two.
Shall to two.
shall to two.
Yeah, because it already has a shall up in the A.
Right.
and
Yeah, that makes
It
sense.
doesn't really follow as a sentence.
Mm-hmm.
Those were the only things, those are the only little things that I caught here.
No, I think it's good.
There was something, I had some comments, does anyone have other comments about I had some comments about the form, the registration form.
Before we get to the form, can I ask a question about the city council adopting ordinance and the fee? When the fee, I know that when the city sets all the fees annually, it'll be in there, but in the interim between when this ordinance is adopted and the city goes to that, how does that fee get set? And does it need to be in the ordinance that the city council adopts the code provision to set the fee on a temporary basis, or is that, or how is that done, I guess more generally is my question.
The staff can come back with fee amendments, and we will be making some other corrections to additional fees, and this could be one of those fees that we would incorporate.
Okay.
And then city council would adopt that independently.
Right. Usually, the authority for imposing a fee is set forth in the ordinance, but we don't say what the amount is, and then we say the fee shall be set by city council resolution. And so normally, if we already know what we think the fee should be, and there's been some kind of a study done, both documents can be brought together, or the ordinance can, or I'm sorry, the fee resolution can be brought at second reading or within 30 days after, so that by the time the ordinance takes effect, the fee is also set and effective.
Okay, but that's done by separate thing, not.
Yeah.
Okay.
Right, yeah, that's a council action.
The only comment I'd have on that is we do want to break out the fee for the inspection, because if we're doing additional inspections, you know, we want to be able to charge for those.
I mean, there could be the basic fee, which includes one inspection, and then have another fee for
Yeah,
additional.
there is a part in the, that says that if additional inspections may be required.
Mm-hmm, yeah.
Just out of curiosity, will any other services be billed back to the client? If water breaks or something like that, city services?
If the city contracted out with an independent contractor that would have to prepare, repair that, then it would be.
But that wouldn't necessarily have to fall under this ordinance. It would fall under regular city business.
It would be like an abatement.
Abatement,
We would
okay.
treat it the same way.
Yeah, okay.
Does the city charge an administrative fee on top of the cost for the abatement or emergency action, or do they just pass it through?
It does not. Whenever the city abates a nuisance, it only charges its actual costs, which may include what we call administrative costs, but those are the actual staff time of people that responded to it, drafted the notice of violation letters, the inspector's time and all of that, and then, of course, the correction.
Okay. So let's, working backwards, do we have any other comments about the forms?
Yeah, I have some comments about the registration form. I think in the introductory part, it should more strongly say that 3 contacts are required, like in bold. Maybe before the sentence says, list the contact information of 3 individuals, so say contact of 3, 3 individual contacts are required. So so that it's clear that we're not just, you know, because people will put one and not fill it out.
Yeah, then they put NA, right?
Yes,
Right.
so, yeah. And then, the first one would be the property owner, and then the second one, what was my thought? I was thinking the second one would be other responsible individual, parentheses, maybe property manager. And the third one would be other responsible individual. Maybe. To me, somehow it just seemed, because it says property manager, and if you don't have a property for the third one, it just says property manager. If you don't have
Just
one,
say not applicable or something.
yeah, someone might not fill it out.
Right.
I just want it to be super clear.
It seems like those two boxes should be the same. It's,
Mhm.
you need a second and a third.
Yeah,
Right? So, and one of them could be a property manager.
yeah, one
but
would be a property manager.
even
Both
if-
of them could be property.
If you don't have
managers,
them,
but-
then you need to, there needs to
Yeah.
be somebody.
Yeah, but I could see people coming back with just, you know, one name and,
And since we have this long gray line for that
we could
person,
say plenty on it, yeah.
and as someone who has spent hours in a fire engine waiting for a person who has permission and authority, I mean, we would get people to come to the scene and they say, well, you know, we need to abate this. And I can think of in a couple places there was a hazardous material incident. And we would get a quote responsible party, but they did not have the authority to spend money or to address the issue. So you were looking at a responsible person, but they couldn't abate the problem. So maybe you would, some kind of phrase, you know, from council that says, you know, with authority to, you know, address or to,
Yeah, I think we have that language in the ordinance, and
Yeah.
we should include that over here.
Right, the way, I mean, if there's a violation on the vacant property, even though you might have an agent come to the property, oh, I'm not authorized to say you can spend.
And
any
I've
money to
seen
fix
that.
it. It doesn't matter, they don't get to say that. It's a public nuisance, and the city will take the action it needs to take as an emergency abatement, if it is an emergency. If it's not an emergency, we'll just cite the property and go through the normal code enforcement process if we can't get one of the agents to say, yes, please fix this and send the bill.
or I have authorization to spend the money to do it.
Yes,
Yeah.
See, we would get neighbors who would give us all kinds of information.
sure.
But when you came to that turning point where you have to abate the problem, everybody gets amnesia or, you know, backs away.
Right, right.
So much a neighbor's gonna do.
Yeah, sure.
And,
And,
yeah, you know, it would be unfair, but that was a real world problem.
and if it's an emergency, we're gonna do an emergency abatement, which does not require prior notice because it really is an emergency. And then we go through the procedure, the process after the fact, as soon as possible, to get the council to approve that there was a public nuisance, that this is the action that was taken, that this is the record of costs, and then to approve the cost bill, which then gets mailed to the property owners. Does any of this sound familiar? Because code enforcement comes to,
Yeah, well, it sounds familiar to me because when we were calling a hazmat company to go in and abate the problem, their first question is always, who's paying?
absolutely, right.
And
But if it's not an emergency.
it's 1 a.m.
Yeah.
and City Hall is closed, and, you
If
know.
it's not an emergency, we can't use an emergency abatement if we're trying to make sure that the property owner is always responsible. It doesn't matter what happened, if they didn't do anything wrong, if somebody else did it to their property, the property owner is always responsible. And so if it's not an emergency, then we've got to back off, and if no one will take responsibility and say, yes, please fix this, while the owner's gone, then it's going to sit there unfixed. We're going to have to go through the public nuisance procedures, I believe. Unless you want me to add something on the emergency waiver form, I don't think anybody would sign it saying, we are authorized to
Yeah.
spend up to 500, kind of like a property manager would. Which is why it would be good for them to have a property manager.
Except on Tuesdays, we'll give you 10%.
I mean, I can remember these things happening in the field, and it may be a city training issue where, you know, people, you know, you can say, well, we now have this ordinance, and, you know, it's listed, and you can proceed with the following caveats, and
But I mean, the
that would be
language
helpful.
at the top does say, list the contact information of 3 individuals that will be responsible to respond or to abate a property maintenance nuisance. So
Okay,
that's what it says.
and it should help.
That almost implies that they need a property manager with some authority. All property managers have authority, at least $300 to $500. That's always part of their contract, because they can't always get a hold of the owner. But if it's more than that, they can't spend it without authority.
Other than, that's all I had on that.
So are we okay with the forms? Should we want to go back to the,
Well, I think the other form, the waiver, the council's gonna add. Yeah, so I don't think we need to see that again.
But I think one question for you is, given the discussion that you've just had, and highlighting some of the both concerns and actual experience of the fire department in the past, are you sure you want to make the requirement to have a property manager optional?
I think so, because I don't know, I just feel like we're probably gonna make it a bigger bar to people actually
Okay.
registering,
Yeah.
and
Or single-family residential property, like,
well, some people, some of the, when you look at the list of when people do this, some of them are properties that are in escrow or properties that are just built, and all those people are professionals. They're gonna have property managers, that's not gonna be an issue. But if somebody, just has a one house that, it's their parents' house that they moved out of or whatever, I don't know. I don't think that's necessarily something we're gonna have or need.
I don't care as much about the title as I do about the authority. So if it's somebody's brother-in-law and they say, yeah, we can do that, go, do it. Well, I just want to get the thing fixed.
Okay, well, that is a potential hole, but there's only so much you can do. I mean, you could write the ordinance to apply to the worst-case scenario, but then it will impose a hardship on others.
Right.
So that's really the policy call that you're trying to make.
In the ordinance, I'm sort of forgetting now, but it doesn't also say if there's any real estate agents?
Yeah.
So
Yeah.
we on the line where it says other responsible party or property manager, you could also put or real estate agent or something like that. Because a lot of people will have a real estate agent that might not have a full-time
Mhm.
property manager for just one house.
Right, the notable squatter situation in the city, there actually is a property manager involved with that property, and it happened anyway.
Well, the problem with that is, under law, if they've been there 30 days. But
Yes.
the second they move in, they've been there for 30 days, unless you can prove otherwise. That's
If you had
always what they claim.
that's the thing, is that's why if you're gonna have a property vacant, you better have good security measures, someone coming to the property every day to check on that, because in that particular case, what they did was they came to the property, they changed the locks immediately, moved in, they set up a account with SCE. They couldn't do it with water, though, because the owner had the water account. You can't have more than one water account on each property. And when the owner realized that they were using water, because the owner got the water bill, that was when it was brought to the attention. So the property manager wasn't apparently aware of this in sufficient time.
Yow.
I'd like to say that it's an isolated incident. It is not.
Wow.
Pretty gutsy move.
I'll say.
One way to describe it.
Are there any other additions or corrections to the ordinance?
Nope.
I think we're good.
I think it looks good.
I think this is, it's taken a while. The city council came to us and they wanted this done, and this is an excellent product. I think it serves the purpose, and it's,
Done a great job on this.
and yeah, staff has done an excellent job, so.
Thank you. So let's see, shall I make a motion to recommend approval of NCPA 1705 to the city council?
We have a motion, need a second?
second?
It's been made and seconded. All those approve?
Aye.
Okay. Passes. Good job. Thanks. Okay, so the next item on our agenda is discussion regarding amendments to the Municipal Code, Chapter 1756, Non-Conforming Use Ordinances.
And Leticia Cardoso, Planning Manager, will be making the presentation.
Good evening, Commissioners. As you recall, at our last meeting on August 3rd, you initiated your discussion of the non-conforming ordinance and potential amendments you would like to see in the ordinance. And at that time, you directed staff to come back with some additional materials to further continue your discussion. Attached, as you requested, are the list of allowable uses and parking requirements in the commercial zone, and a cross-reference between the City of Pasadena non-conforming ordinance sections and issues recommended by staff to be addressed in the revised city ordinance. Staff also included, just for easy reference, once again, the non-conforming ordinances from Pasadena and also Sierra Madre. Now, just wanted to clarify the matrix that is included is a little bit revised from the original recommendations. They have been repeated. Some of them have been further expanded on, and you will notice that on some of those it is blank under the City of Pasadena section because it is more of something that staff included there for discussion and doesn't necessarily specifically has a reference in the City of Pasadena ordinance. After the report was prepared, staff also noticed, and it's on the dais in front of you, there's another section in the commercial zone ordinance that pertains to requirements for CUP as well, which I thought you might be interested also in considering in view of your review of those uses that require conditional use permit in the commercial zone ordinance. It's section 1736-030. As you can see, it includes conditional use permit requirements for any new construction, additional floor area to an existing building, or enlargement of an existing building that requires a CUP. Section B, subsection B, states that exterior facade alterations do not require conditional use permit, and interior alterations to an existing building which does not involve the expansion of floor area or an increase or intensification of activity. The reason this was included here is that you can see, for example, if a use does not require CUP, but you are expanding that in an existing building, then you would trigger CUP.
Right.
And that seems something that you might want to be aware of, that there is this requirement, potentially decide whether you think that that should remain as is, or maybe some modification is.
But then we also, when we start talking about facade alterations and CUPs, we run into the same issue we've seen in other sections of our code where we're really not talking about use issues, we're talking about design issues.
Right.
And so I think one of the things when we start digging into the commercial code is we need to start thinking about, you know, which one of these needs some sort of use regulation, and which one of them do we really want to get more to a design regulation.
So at this time, staff is seeking further direction from the Planning Commission regarding the ordinance. And this concludes my report.
Okay. Commissioners, what's your... Oh, we have, yeah. Is there anyone here from the public who wishes to speak on this ordinance? Thank you for coming.
Yeah, thank you. This has actually been very interesting. Maybe not for you. My name is Femi Tuntisi, and my husband and I, we live in Altadena, 2670 Lake Avenue, Apartment 4. Been coming to Sierra Madre since 1964. My grandpa lived here for 30 years, and we are looking to start a small business here in Sierra Madre. But we just found out about the CUP, I believe is what the acronym is. And that extra fee regarding that would really change our minds, whether we would be able to financially start a business here or possibly look elsewhere in other communities. So, yeah, we were completely unaware of that. So I wasn't even quite sure what that money was regarded towards or for, or why that was even there. So.
What type of business and how big a space are you looking at?
I'm actually looking at the 122 East Sierra Madre Boulevard. So it's in the back lot of that Sierra Fusion restaurant, and I believe it used to be an old Ford delership, and
Yes,
they've
it
been
did.
converted. Yeah, it's pretty cool. It's a wonderful building.
Wait, you're down below?
Correct.
Oh, that used to be my office.
It was?
Yeah.
Ah, why did you move? It's
It's a
such an
great
amazing
space.
space.
It is a fabulous space.
It is. It's a great space. So the business we're looking to start is a very small boutique Pilates studio. Only 4 people would be there at a time, be very quiet. It probably be on the hours of before those other businesses even start and then after they close. So it's kind of dead in the middle of the day. I have, what was your name again? I'm sorry.
Leticia.
That's right. I had spoke with her twice about this, mainly because of the parking. We were trying to see if there was enough parking, and there certainly is, which we determined. So then she told me about that extra fee, and I was like, what? So anyway, if there's any possible way to avoid paying that or having that just taken away from that completely.
I think you'll
Well-
find that it's not, this happens in other cities as well.
Does it? Okay.
Yeah, for that kind of business, because I have a friend who was opening the same sort of thing in Arcadia and also had to get a conditional use permit.
Really?
It's a
Okay.
pretty usual thing because of looking at the impacts that a business may have on the area and parking and other issues. So it's
Does it
not
have-
an unusual, it's not an unusual thing that it has to get looked at by staff to make sure of the intensity and so on.
Right.
And that's why it exists.
Does it have to do with
But-
the size of the business? Like, again, mine would only
Gotta be
have
the use,
4
right?
people at a
It has to do with
time.
the
Right.
use.
It's a use issue.
The use,
Yeah.
okay.
And right now, it doesn't, I mean, that's one of the things we're talking about is whether we should make exceptions for smaller businesses.
Right.
Because it seems like a very large burden for a small business, as opposed to if you're gonna have a giant, LA Fitness
Right.
thing. And so that's,
But
something we really need to
in
think
this
about.
instance, is it, I mean, obviously it's a use issue, but I don't know that building, but is the current use there like office or
the prior use
general?
was office, yeah.
Okay, so this,
It'd be a change of use.
Mhm.
It also is listed under as R&D, so I don't know if it's only office or,
The big picture is that municipal governments have this in place so that they can control what happens inside the city boundaries.
right,
Because, you could wake up one morning and your city is nothing but, I don't know, I'm picking something out of nail salons, and that's probably not the way you want your city to look.
right,
And, there are businesses that come and go, and each one of them has their own impact on the municipality and the services that they look at from the municipality. And at some point in time, the municipality has to have some input and some kind of say in exactly how much things are gonna change. And because the citizens look to us to make sure that, they like Sierra Madre. And, when we got this job, we were told you could do anything you want, you just can't change anything, so.
right.
So, so they're kind of sensitive to change, and
The
so,
KFC is gone. That was huge change.
yes, it is. But it was replaced by another restaurant.
That's correct, yeah.
And so it's perceived that the impact in the community is somewhat mitigated in that regard. But if they wanted to take out the KFC and put in something that was entirely different, then there might have been some more discussion involved, and that's what you're going through right now.
Okay. Okay, well, thank you for hearing me. Appreciate it.
Thank you for coming and
Sure,
and
thank
speaking to us.
Hi, my name is Deborah Plummer. I live at 115 East Laurel in Sierra Madre. I'm actually a realtor here in Sierra Madre with Podley Properties. And I'm kind of speaking for Poly Properties. We really would like the city to consider allowing some new businesses in Sierra Madre to have maybe a little more variety. You know, we have enough nail salons and beauty salons, and we just think it would be nice to have a little more variety inside our city. And we would just like to encourage small businesses to come and not have more restrictions on them. So that's all I have to say.
And in your experience, you found that as the lady who spoke to us earlier, and I know this was raised when the optician was here before, that the CUP requirement is a very big burden on attracting small businesses. Is that right?
Yeah, yeah. We don't want additional, you know, restrictions on businesses.
Well, yeah, I know, but I mean, nobody wants restrictions, right? But the thing is when you try to craft the regulation to help the community get what you want, you try to balance the cost benefit, and one of the issues that we're looking at is the cost that it imposes on small businesses worthwhile. And I think that from what we're hearing is that it's not just something we sort of don't want. It's a really big issue.
Okay.
And as you know, we have to consider a number of things. If on your business on Baldwin, parking is difficult, a challenge.
It is. It's a challenge.
And so one of the things that we have to begin to weigh is if there are a number of businesses that want to move into town that require additional parking and lots of parking, that would impact everybody's business, including yours. And then we may hear back from people that says, well, we want that more controlled. And so those are the kinds of balances we're trying to work out.
I think we've worked, you know, parking is a challenge. However, there's free parking just down the street, just a few blocks from all the businesses right around, you know, the center of Sierra Madre. It's very workable. That's where we tell people to park when there's nothing available. The 20-minute parking works well for all the businesses around there. That's usually enough time to go get your coffee at Starbucks and whatever you need to do. So, you know, parking is an issue, but I don't think it's impossible to park and do your business in town. So I don't think parking is that bad in Sierra Madre.
Not,
I mean, the issue is not, I don't think it's that bad now either. But the issue we're sort of grappling with is if there's an intensification of uses with new businesses that come in, which is what this is all about really, then the parking gets worse,
Yeah.
right?
Mm-hmm.
The parking could get worse if you have businesses that have more people coming in. So that's sort of the issue one of the issues that this is kind of trying to address.
right up the street from you is an empty building, was Charlotte's Jewelry.
Yes.
And if that were tomorrow to become a barber shop with 10 chairs, they would want 10 parking spaces for the 10 patrons, which would take up all the parking spaces on your side of the street.
Mm-hmm.
And then it may be that you would come in and say, we have no place to park.
Do we know how big that space is? You don't happen to know.
So these are the kinds of things that we would at least try to consider and take everyone's concerns into consideration.
We just don't want to discourage new businesses.
Yeah, well, neither do we.
Yeah, no.
I mean,
And a variety of businesses. So that's just what I wanted to say.
I don't think we disagree with you.
No, we don't disagree.
We don't disagree with you.
Okay,
But it's
thank you.
figuring out how to encourage and protect, which is.
I mean, John's point, I actually think, and that's not what we're discussing here, but I think those are some high bars for small businesses. Like, I
Right.
mean, we can't discount that cost, you know, because it may be one cost for that business to occupy that space, but that's on top of
Everything
a
else.
whole litany of things, you know, when you're starting a business, like, that isn't the only thing you're paying for. And
Not only
that's
that,
not our
but-
problem, but the
yeah.
point is, I think it's a shame if, you know, we really want to encourage small businesses and a variety of businesses. I think that's a hurdle sometimes that can't be
And-
overcome.
and
And
I
I
think
think
it-
there's another part of the hurdle is not just the money that it costs to do it, but it's the time, so.
And the risk.
It's the time and the risk, so you find a place you wanna rent, and you grab it up because it's like the perfect spot, you think, and then, if you're not a very experienced business person, suddenly you come up against the CUP thing, which could take quite a while.
Yeah, it could take a
And
few
you're-
months,
It
and
could take a few months, and in addition to the time it takes to build out your space or whatever, and pretty soon you're looking at 6 months of rent where you're not doing any business.
Yeah.
And this
It's
happens to
huge.
people.
It's huge.
It's huge, it's gigantic.
and the thing is, you know,
And
if you're
that's where it really becomes
if you're
a barrier.
prudent, you don't spend a lot of money building out the space until your
Of course.
CUP is approved, because if it's denied, then you're in
Right.
deep trouble.
But
So then you
you're-
don't start work until after your CUP is approved, and you might be looking at 8 months to a year before you move in.
And you might have
But you're
had
still
to rent it
paying,
already.
you're still
You're
paying for the
rent.
space
Yeah.
potentially.
Right.
Yeah.
And so what you do is, instead of renting that space, you go somewhere else.
Mhm.
And then, I'm more familiar with the landlord position. The landlord says, great, there goes another potential tenant that just left.
Yeah.
And as a community, we have a vacant space instead of somebody that's generating tax revenue,
And services.
employees that are, you know, going to restaurants and,
Passenger traffic on the street.
and also services that people in town could use instead of driving to Pasadena.
And so how do we understand what is a small business?
Well, I mean, I didn't want to jump in, but the point is, to me, the CUP is triggered on a change of use, right? In
Right.
this instance, I don't know if we can look at it more broadly, like, for example, if you're changing from like a professional office scenario to like an urgent care, you know, situation. Okay, I mean, we're talking apples to oranges, like, you know, there's, that needs to be looked at in a way that you wouldn't look at necessarily going from professional office to, you know, a counseling, a place where only 2 or 3 people, you know, you have one client coming in, you know, I don't know, something that's similar but different, you know, like, is there a way
Well, I
that
think
we
there's-
can,
I think there's two
more common
sort of
sense, you know?
ballpark of issues. One is the sort of general concept of intensification, and a lot of times that's quantified in parking.
yes,
Then the other is just actual uses that may be problematic. So if you're switching from, you know, general office to a liquor store or a marijuana dispensary, those are big issues
Yes.
that it doesn't matter how big it is, right? But if you're switching from general office to an optometrist or a Pilates, and by code, you know, we might require one more parking space. Are we going to say having a $5,000 X month delay is worth all that for one parking space when we really do have enough parking, you know, in the lot behind?
Of course.
that
I
seems
mean,
like
so
a
that
common
to me seems like when you're dealing with the intensification issues, that really is size dependent. Because if somebody was coming into a 20,000, if Howie's was redone with something that was a really big
Trader Joe's.
intensification, that's something we'd want to look at.
Right.
Or if
The
there was,
fresh and easy.
or if there were a new building, right? Because that's not something that's sort of baked into our existing parking. But, you know, if you're turning over 1,000 square foot, 2,000 square foot spaces,
I mean, I think that, you know, I mean, imagine it's, you know, an office with a few people working in it, and now it's a restaurant with liquor service, you know, that's a change.
yeah, I agree.
But if you're, you know, changing from an office use to another similar use, or even to, you know, and there's some kind of in between, because retail uses can be fairly varied, you know, so that.
Right.
If I may, one thing, just to clarify, that CUP is not always triggered because it's a change of use. It depends on the use that it's changing
Right.
to.
right?
Yes,
So,
so there's two issues.
right, it's not just an automatic because you're going from office to a Pilates
Right.
studio. It's whether the Pilates studio requires a CUP, then that's what's
But I
what it
think,
triggers.
I think one of the things we have is, if you look at our use list, we've got a binary choice, permitted or CUP,
Yeah.
and it doesn't matter what the size of the space is. And really, the way we should look at this is, we should look at reusing existing spaces, and we should go by size, and we should say permitted, minor CUP, and then we should look for new businesses. and so I think it's much more of a grid than it is yes or no.
Yeah.
And,
I was-
and that gives us an ability to have a finer distinction, so smaller businesses don't get hit with the big hammer.
I mean, it seems like the sort of, and I don't know I don't know in that much about the exact process of the minor CUP or whatever we're calling it now, but that there are plenty of cases where you can, so to take a quick look and say, yeah, this isn't going to have that much effect on the city's environment if it changes from an accountant to a Pilates studio. And that could be a minor, I mean, it gets a look at, because we
Right.
want it to have a look at, not just, go ahead. But it could be a quick look. And
Well,
it
a
doesn't
minor
need to go
CUP
through.
is you send out the notices and you wait 2 weeks.
Yeah, I mean, a quick look is for most of the businesses turning over in Sierra Madre is plenty enough, really. But for some types of businesses, you definitely want the entire CUP process to go forward.
The other thing is how we define what the business is. I'm not sure Pilates Studio is on our list because they are something that's
Yeah,
more newer than our,
it falls into the category of.
you know,
It falls
so
under gyms and
gyms.
fitness.
Clubs or
and-
center
and-
The
exercising,
closest,
maybe in
it-
fitness studio.
it could be easily argued that 4 Pilates stations and a gym are 2 different fish. And their intensity and impact on the community are different. And that may be something that we would want to spend some more time on in terms of, okay, how exactly do we define a gym? Because it could be a 24-hour fitness, or it could be, a small business with, 4 Pilates beds, and,
A
so
personal trainer studio.
a
which is
personal
whole
trainer,
different thing
yeah,
than a 24-hour
with some
fitness.
with some medicine balls, and that's it. So, and especially now we're looking in this day and age, in addition to having large institutions like 24-hour fitness and whatever, we're also having boutique, and Sierra Madre seems to be a community which is more receiving of smaller boutique types of services, and so, yeah, I think that's our definition of how they're using it, and the intensity is something that we should probably.
And it also varies with the size of the space,
Right,
definitely.
yeah,
you know,
right,
so that
because
they,
if we're
give a
talking
look-
on 900 square feet, I don't know that we care so much what the
Right.
difference is, because
Mhm.
it's not worth.
In that
So
example.
just to butt in, because this is just not on the agenda
Right.
tonight, I mean, this is a great discussion, but do you want to give direction to staff? Are you interested in reviewing or revisiting the uses in
Well,
the
I-
zoning code under the various commercial areas to see whether we should consider amending things that are use as a matter of right with the
And
CUP?
we-
Came up with a
and-
discussion
Yeah.
last time.
And that's
where
why
were
we
addressing
have the uses.
We were
Yeah.
addressing the non-conforming ordinance, and then we took a
Mhm.
step back and said, wait, on the way to addressing the
Ah.
non-conforming ordinance, we really need to take a step back and look at
It was really the
what is
parking.
conforming,
Yeah.
and figure out a way we didn't feel like we could get to the non-conforming until we kind of took a step back and looked at these issues around parking and uses.
That's why the
It's one of
parking is in the
Right.
Because
for
one of
staff
the
report.
issues was, one of the issues brought up in the list that staff provided of things to consider in non-conforming was whether if one use vacates and a new use requires a CUP, it's the same type of use, but the previous one did not have a CUP, is the next one required to have one? And that, I think, kind of triggered the whole
Right.
issue
And can
of,
they maintain
What's the
their
process?
should we require
And
a CUP?
I think,
Went into that.
I think it does make sense for us to sort of step back and say, well, what do we want to tackle now? And which of these are so intertwined that we have to deal with them together? And which can we sort of say, well, let's, get to that one later? Because we could always just redo the whole code, That's right. So I think the first thing to say is I think it's, generally the way we should do this is we should do a subcommittee, because it doesn't make sense for us to go start modifying code at the public hearing. We should talk big picture stuff. I think that we really need to do the commercial ordinance at the same time. I don't see how we can really touch this properly, because the whole issue of the use changes really gets into the commercial ordinance. The parking, I think we can deal with the issues of adaptive reuse and bonuses for parking, or having the existing parking count without going into the full review of parking. And I also think that if we tried to do a full redo of parking, it might be more politically troublesome and it might bog us down. And so I think that's probably something to wait. There's a lot of discussion in the general plan about parking and adaptive reuse and bonuses. So I think that's more of an issue that we can solve without addressing the bigger parking issues. Although I think that's something we should do at some point, but you know, we could put it on our to-do list. So that's really what I think we should do, is we should focus on those two things. There's a couple of other little things that we might want to talk about. I remember at last meeting, we talked about the non-conforming stuff in the canyon, and it was my memory that there was specific code provisions that dealt with commercial uses in the canyon. It turns out there's not. There's just one that says all legal non-conforming uses are allowed to be non-conforming by the non-conforming ordinance. But there is a big provision in the general plan that talks about the continued use of multifamily and retail uses around the parking lot. And so that's one thing where the canyon zone and the general plan don't mesh. And my sense is that's not a pressing issue, and maybe that's not worth us trying to tackle now.
Yeah.
I think the thing around parking was that when we have conditional use permit applications come to us in the commercial zone, it's almost always issues about parking.
Yeah. And the other thing,
I mean, the other issue that has come up is like, you know, it's they're selling liquor in a restaurant or something. But most often, the issue that it boils down to is the parking issue.
and I think the
So-
liquor issue is not a big issue, because I think everyone agrees that that's something we want to have a full CUP
Yes.
for, right?
Yeah,
So
yeah,
that's pretty
yeah,
that's pretty
yeah.
easy.
But
The
mostly it's the parking
right.
thing is what comes around, and it's a complicated thing, because if it's you know, what we were just talking about, if it's a CUP that's trading one small use for another small use, which has a pretty similar intensity of use, they still have to go through the process. And generally, we're like, yes, we're gonna let you count the parking that's there, and you'll use the parking in the back and go ahead. That's what's mostly happening. And so there ought to be a way to kind of make that work without having to go through this whole thing, where what we end up with is no real benefit for all the time we spent on fussing about it and staff spends
Yeah.
on it.
But-
Now, just to
And so I
clar-
think that's how these things are all connected to each other in a.
I mean, it really started with the CUP, you know, a change in use,
Mhm.
right?
That was one of the questions.
Yeah.
Whether the commission wishes to require one or not. That same use has been there before. But the other question about the parking was, currently that's a policy to allow a credit. If it is non-conforming, if the next business has the same requirement, excuse me, it takes on that non-conformance. And the question was whether the commission wishes to codify that and allow for that grandfathering in as a way to address the shortage of parking in downtown that is very hard to get resolved, and I don't know if you ever will, but that was the question, is
Well, I
whether
think-
you want to
right.
codify that. It's been a policy, but, and the other thing is that the projects that come to you don't come to you because of the parking. They come to you because that list
Right.
of uses requires that it do so, and in the process, it has to be shown whether they comply with all the zoning ordinances, and parking is one of them.
Right.
So,
But really, I mean, the reason they're on the list is because of parking.
as you mentioned, that the
I think that's-
intensification is often reflected in
It's
the
really
parking.
I mean,
yeah.
we should, you know, think about the list and think about things that it's not an intensification issue, you know, liquor stores, and in the commercial zone, we're not gonna have like welding and, you know, sort of other kind of things that have more industrial externalities. But I think that, I definitely think we wanna codify the current policy, and I think we even wanna go beyond that for adaptive reuse, because I think if you, especially for small spaces, it just doesn't matter. You know, if we're in this requires 2 spaces or 3 spaces or 4 spaces, and it has 2 or 3, and we're doing all this for 1 parking space.
Yeah.
It's just not worth all that hassle. I also think that, you know, the whole concept of when we think about non-conforming, and when the magical everything goes away and you rebuild under current code, what things would look like. And we fundamentally have a suburban car-based code,
Yeah.
and our town is a suburban trolley car town.
Mm-hmm.
And so if our downtown disappeared, it would be rebuilt totally different, and I think a lot of people would be very unhappy.
Mm-hmm.
And in a lot of ways, the parking lot on Mariposa functions like our trolley car, because that's where you come with your car, you park once, and then you walk around. And that sort of works. It's not the same as a trolley car, but it's very similar. And I don't think we want to get into the place where we're starting to require each and every one to have parking on site, so that we start moving buildings apart. I mean, that's would destroy the charm of the downtown.
Right. I mean, especially if you think of Kirsten Court. I mean,
Right.
there's no place to put it.
Right.
If you start having to have parking, then there's no place for buildings, and we certainly don't want to go there. And that applies to an awful, most of the places, right?
I mean, I think another aspect of it too is this idea of, that's not an antiquated, but it's a slowly disappearing concept in time. If we want to really be forward thinking about this, like the idea of housing cars, in order to access your retail, your commercial base, like that's,
Going
it's being
going away,
disrupted by
yeah.
a lot of other
Right.
ways to get there. Feet, bike, Uber, whatever. Like, there's going to be other modes of transportation. So the point being, I don't think it should be based around we need to park the maximum number of cars. I think this idea of congestion or not being able to, I think it's a non-issue in the long term. And in a weird way, it's kind of a good problem to have. Like, that means you've got a busy commercial base where a lot of people are trying to get to, like.
Yeah, but on the other hand, in my example, if they take the Charlotte's Jewelry and it becomes a, some kind of beauty establishment.
Or
I-
restaurant.
Or a restaurant.
Well, or a restaurant, we would hear from all the other businesses on that side of Baldwin, because suddenly their patrons would be displaced. And there's some shops on both sides of the real estate company. But if they were to move up just a little further on Baldwin, where there was a beauty store and it has parking behind, that could happen tomorrow, and no one would even
Right.
no one would bat an eye, and they would think it would be a wonderful thing. So, while I agree with everything that's been said here, I think that when it hits the streets, that there is a concern by the business owners, the existing business owners, on what is an impact of this change of use and intensity of use. So, while I agree that current parking regulations, I think, are going to get pushed back more and more in order to put pressure on the public to find alternative ways of, walking in the door. I don't think they're going to go away entirely, and I think that the business people are going to be a little anxious up until they come up with get comfortable with whatever Plan B is.
But I mean, in your example, which I agree with, I don't think other businesses are being displaced. I think they're all fighting for
The same spot.
pool of parking,
Right.
which is, your Mariposa lot, or up Baldwin, there, or by the mailboxes,
Right.
like that restaurant now isn't displacing patrons for the other businesses. It's just those 10 people are now fighting over the same finite amount of parking.
Well, I also think that I agree with you to a certain extent about the sort of general trend of parking, but I also think that's not necessarily a discussion we need to have in order to deal with the issue of adaptive reuse of existing spaces. And I think there's a lot more buy-in on that, and we can tackle that issue and get it done without going farther. I mean, if you have something out by where the KFC used to be, and someone wanted to build a big commercial building, there might be big parking issues there. That's far away from the parking lot, the Mariposa lot. We should look at that new thing. But if somebody's converting, a small space,
Storefront, do another storefront.
I don't think we want to.
I agree.
Over the parking issue, that's almost a rounding error for the whole town. hold
Yeah,
that up.
I agree.
The other thing is, you know, we talked about the in lieu fee last time, and I actually looked it up. We got rid of that in lieu fee in 2006.
The what?
We used to have a parking in lieu fee that
Oh,
if you
right,
couldn't
yeah.
meet your thing, you could pay. And
Right.
it was $2,000, which is a joke.
And then they got it back.
But the thing is, instead of like fixing it and saying, well, what should it be, and putting we just deleted it. And it's like, well, that doesn't seem to be really the best way to deal with the issue. But so it may be that if, you know, you have a certain size, we're just not going to sweat it. And then over a certain size, maybe we do have some sort of review, and maybe an in lieu fee is something we can use. I don't know.
I just want to digress for a minute to the non-conforming uses in other zones, because there are some. There's not as a, and I think what it seems to be is mostly the commercial zone, but there are some non-conforming uses elsewhere. Some of them are houses, residential.
Well, those like are,
East Montecito,
Yeah, residential
yeah.
in the
manufacturing
in
zone.
manufacturing, residential, and commercial. But are there other non-conforming uses in the residential zones?
like the
What are they?
The Penny House is non-conforming,
Yeah.
actually. It's multifamily and then resident, R1.
But it is
Um,
another residential and a residential. I'm just
Right.
thinking, I'm trying to think
There's
if
also some, there's some other multifamily in Canyon,
Uh-huh.
but those
But
are,
it's less of an issue because it's, even though it's
it's an
an
intensification.
intensification,
Right.
but it's not a different use.
yeah, there's
I
still
really-
residential.
And there is what Letitia brought up last time, there's residential in the commercial zone
Right.
that's street facing. There's
Mhm.
a couple of small lots that have that.
Yeah.
Oh, yeah.
I mean, I can't really think of them, but that doesn't mean they don't exist. And I just want to check. The what?
Like Mary's?
Well,
Yeah, Mary's,
Mary's-
that was mentioned,
Yeah.
Mary's.
Behind Panatorium, right, there's a,
Pentorium, that little,
Residential in the
tiny
com-
little property.
tiny little house,
behind
yeah.
House, that's
Yeah.
actually commercially zoned, but it's a single-family residence.
Right.
There's also, well, according to the general plan update, the residence south of the sanctuary for Sierra Madre Congregational Church, will be a commercial zoned
Oh.
property once we do the
Uh-huh.
Mhm.
matching of the two. So that's a single-family residence as well.
But there are,
It's
my perception of this is accurate.
It's a handful.
There's not
Yes.
but there's
I mean-
not a lot of offices out in some neighborhood or something
No, I
like
mean,
that.
I'm not thinking there is, but
Right.
I just want to kind of double check that, just to,
I mean, I
Make
think
sure.
we kind of figured out last time, at least on a basic level, the non-conforming issue really breaks down to, for use, non-conforming uses is really in the commercial.
Mhm.
yeah.
But non-conformance in other physical manners or with setbacks or
There's a
things,
lot more of that.
that's in the residential.
Yeah.
Yeah.
That's,
Yes.
yes, the structural stuff.
Yeah.
Mhm.
The other issue we talked about a little bit last time was the reuse of historic structures. And I remember that there was a code section on that, and I looked, and all it does is bed and breakfast in historic single-family houses.
Mhm.
So it's not, in a lot of other cities, they have things where you could do office or something like that. And also, we don't have anything that allows bed and breakfast in historic multifamily, which seems
Mhm.
sort of strange to me, because I would
It's
think.
natural.
It was done intentionally for that one building.
Right, and so
And
it's
it never
done
was
narrowly,
used.
but if you're gonna have that concept, I mean, I think if you reuse like the Gill property,
Mhm.
I mean, that could be a bed and breakfast. Or you might have some historic buildings that you might think of sort of uses that would be similar to the RP overlay, you know?
Mhm.
And that's the kind of thing that a lot of cities have. We could think about if we wanted to allow that kind of thing. Because it's something that encourages preservation of historic structures.
So-
Comes up against the fight of preservation of housing for people who need permanent housing as a place to live, rather than converting it to a bed and breakfast use.
Well,
So
yeah, but I think
those are conflicting.
the few times you're going to preserve historic structures, you're probably not maximizing housing. I mean, the way to maximize housing is to tear down the historic structure and build an apartment building, right?
Yeah.
But I don't think there's a lot of, I'm not a big fan of that as the only way to provide the housing.
You proposed a subcommittee. I'd be happy to serve on one. What would be the scope?
Well, that's what I think we need to decide. I mean, how far do we want to go? To me, I really think we need to, if we're gonna start getting into the use part of commercial, that's the core of the commercial code. There's not a whole bunch else. We really need to do the whole commercial code. And because you've got the CUPs, right? But we've already found the issue with CUPs is we regulate design by CUP. And a lot of the stuff, the reasons why we have the CUPs, nothing to do with use.
Mm-hmm.
And so if you're gutting the use provision and redoing it, you might as well then look at the design standards and figure out where you want a design review permit or an administrative design review permit. And then there's not much else. You can look at the design standards, but the design standards are really thin, and I don't really think we want to have a whole bunch of design standards. Eclectic commercial is fine.
From what I've heard from other commissions is that the minute you put into code design standards, everybody builds looking like that. And you end up with Santa Barbara where everybody has a tile roof, you know, and I guess in Santa Barbara it works, but I think we like the more eclectic style in this town, and things need to be different. What you want to be able to do is at least to speak generally about articulation and massing and things like that.
And if you look at the commercial code now, it actually says you have to build with 5 different materials.
Yeah,
Which-
I've seen that
which
before,
is-
which is ridiculous.
Which to me seems counter to what we want.
Yes.
There's discussion in the general plan that says we want to encourage quality materials such as, and then that makes its way to the code as you have to use these, and no, we don't want that. And so, you know, there's a little bit of tweaking, but I don't think, I think we need a very light touch on that, and if somebody's building a big building, you know, if we run it through our design review findings, I think that would work fine. I don't think we want to get into a lot of specificity about the kind of
So I should
columns
probably
that
ask
you-
staff about how they feel about the subcommittee.
How does that help inform this non-conformance codes? I mean, like how, does that need to take place and run its course before we can sort of
I think you
slice and dice
I
this?
think you want to look at the CUP requirements for use and the adaptive reuse of space and nonconformance, those issues together. I think you sort of have to do that.
Because I think that
But I think you're
as we look at this, as we look at the, you know, we have now a list, this crazy list of, someone tried to think of every possible use under the sun that could happen in the commercial zone, which is pretty hilarious to me. But so many of them are so specific that it's kind of ridiculous. And that, I mean, there are some things you definitely want to look at before they open in Sierra Madre.
Liquor stores.
What?
Liquor stores.
Liquor stores.
Yeah.
Yeah. But a lot of them doesn't really matter that much, and the way it's handled doesn't facilitate that, doesn't facilitate people wanting to come in and open a business, which is benign.
Yeah, I
And positive, and there must be some way to kind of do this, the non-conforming issue and, you know, how they roll over, and the CUP issue and the list of businesses, and they're also interconnected. It just kind of makes sense to kind of come up with.
And I think it's actually a pressing issue. I mean, we have, because of the water moratorium, we have a reprieve on a lot of new construction and residential.
Mm-hmm.
You know, we talked about the canyon, but I don't think we're worried about Mary's Market switching over that much. But we do have vacant storefronts where RC Modeler used to be, you know, and there's some other vacant spaces in town. There's like the one you mentioned up on Baldwin. And so the ability to fill those spaces and what goes into those spaces this directly impacts that.
I agree that I think we need some kind of discussion and some kind of in-depth look at the vortex that includes size, intensity, and what is happening in there. I mean, if Taylor's Meat sits in a part of a building that's empty, and if somebody wants to go in that other part of the building and put in a rifle range, we might have a problem with that. But if they want to do something else, it may,
sorority house.
So
Yeah.
Is that on the list?
So,
Yes, it is.
Oh, God.
so,
Hotel, right?
you know, the problem is that I think, and sometimes when you sit up here, you think of worst possible case scenarios, and you try to guard against those. But in that process, we all then also put up some boundaries for someone who wants to come in and put up a Pilates studio, because we equate Pilates studios and a gym. And sometimes the gym is 24-hour fitness, and the Pilates studios is this little thing. So I think size and intensity have to be somehow in that mix. And I think that a conditional, the CUPs can come in different flavors and sizes. And I think figuring out that table is going to take some off-the-record time for a few of us, and I'm more than happy to do that.
Right, and you bring up one of the other things is the one of the issues is the time that the place operates. And so if you have, you might have something where instead of going by use and guessing what uses typically go later, or you could just say, anything that stays open before X o'clock or starts before there, you need, CUP. And that way, you're not putting a hurdle on something that might or might not happen. If somebody wants to operate a restaurant till, 11 p.m., they can. That is an issue that might actually.
I mean, on the flip side, it could be also where you have uses that don't overlap, and so like the shared parking thing, like suddenly, if you're open at 5 a.m. to, 8 a.m. and then in the evening or something, kind of like the brewery, that whole thing, like parking, which usually wags the tail, that was a non-issue because they were sharing it, they were using it in the off hours.
Right, and the mixing, and that's perfectly true, the mixing of especially restaurant use and office use is a great mix to maximize the parking spaces.
I mean, it sort of brings up the issue of, yes, but if someone wants to stay open from, till 3 in the morning, clearly this is something that raises a flag.
Well, yeah.
Well, yeah, that's where you have to set some
So
standards
there's
or
some,
limits. But
there's some pretty obvious permutations of this, but
I'm still
it's
trying
the
to.
idea of complementary businesses is.
I'm still trying to figure out. So that makes sense to me to study that offline, but does that put this thing kind of on pause, or is it, because to me, when I'm looking at this list, this matrix on the nonconformance, I mean, the CUP or the change of use and whether that, that was like one issue, but there's like 9 or 10 other things.
I just like to.
Can we continue
Well,
on that,
I think
or
what we should do is we should talk about how we want to do it, and then what the scope is, and then say which are the issues that we feel we need to talk about, sort of at a policy level here at the full commission, and then talk about those, and then delegate all the rest to the subcommittee to get stuff. So to me, I think that a lot of those issues that were identified, we should talk about, right? But first, we should figure out what the scope is, and what we want the subcommittee to bring back to us. And then we should talk about sort of those bigger policy issues. But I don't want to start getting into the code,
No, I agree, but I was more looking at this matrix that has been put together with sort of, these are the primary issues or things we need to address for this code to work properly. How many of those sort of fall into the camp of it needs to be sort of vetted and studied offline versus things we can readily address here?
I mean, I think there's, part of the issue here is there's non-conforming structures and non-conforming uses, which are both part of this thing.
Right.
To me, I think the non-conforming structures issue is
I
an
think we
easier
can-
one
yes.
than the non-conforming issues.
Uses, yeah.
I mean, uses, yeah. I mean, I think the
Because the
non-conforming
uses thing, we've agreed, kind of really revolves around commercial.
Right, but there's there are a lot of non-conforming structures all over Sierra Madre.
Well, which is a huge part. I mean, that's everything in R1, 2, 3.
Yeah, there's so many, and we see them. We've seen a lot of them.
But I think
and I think that one is kind of that part is easier to address.
I think that,
than
in the
uses
residential,
part.
I think it's easier, because it's in the commercial, they overlap, because you have the issue of a non-conforming structure with a non-conforming use? And then do you want to like limit the ability of that
To change.
because you don't want that use to continue?
Right.
Whereas in res, you know, the
Residential
use is, the use is fine, and
Yeah.
so it's really a design issue at that point.
Mm-hmm.
And it's a different beast. The other part is, I know a lot of cities, and our current code even has this thing about phasing out uses.
Yeah.
I don't think we want to touch that. I don't think there's any desire in town that anybody who's here and doing what they do to kick them out. That's just not what we need.
Do we have any idea how many non-conforming uses we have? I mean,
You mean like actual cases of that?
yes, actual cases of non-conforming use. I have no idea.
I mean, how would you
even know?
unless?
Well, I
it-
guess it also depends on what level of use. I mean, like, because we talked about the bank has a non-conforming drive-through that's sort of like a use, but that you wouldn't say but the bank use is not
Right.
is conforming.
Yeah, I mean, there's non-conforming uses
I
on,
don't,
on
I
East
just on a windshield survey, I would say, I don't think there are that many.
And the res, even
At least the obvious
Use.
ones.
Use.
Use.
And,
right,
like,
right.
the
No,
res-
buildings, there's
Structure,
plenty.
that's a different.
right,
Yeah,
and
absolutely.
the residential use in the commercial is sort of in the wrong place, but it's still a use that's allowed. It's just supposed to be on the upstairs or
Yeah.
or behind. So to me, it seems like outside of East Montecito, which is, you know, it's all its own ball of yarn, I don't think we have a lot of at least
That's right.
glaring use issues.
Yeah, I mean,
Agree, yeah.
or if they're there, they're not causing a problem that's obvious to anyone, so that,
And so we're looking at this non-conforming issue because you anticipate that at some point in time, the use of some structure facility will change, and you want guidance on what to do about it?
Oh, yeah, I mean, you do have, I mean, first of all, the existing non-conforming ordinance is, I would say, almost unusable.
Yes,
I've rarely
I-
found
we agree.
any answer to questions in that ordinance, so I think that desperately needs to change. We run into a lot of issues in residential, in buildings that have been there, garages or accessory buildings that are falling apart that need to be, that the owner wants to replace and can't often do it because it's on the property line or what have you. A lot of the non-conforming issues really are in the residential. We rarely run into non-conforming issues, whether it's use or even structures in the commercial zone. Parking
for the
is
parking.
the issue that we
Except
run
for
into
parking,
in the
yeah.
commercial zone.
So what you're looking for is guidance in, there's an existing structure because, and this town is, 200 years old, that's been sitting there for X amount of time, and over time, the lot lines or whatever has changed, and the building codes have changed, and what, they want, because it exists there, I want to replace it, and the code has changed, and they're up against new code, and okay.
Yeah, it's just a host of issues that don't always come up, but can come up over time. And the ordinance is not helpful in addressing them.
Well,
They're very limited, and so those things that were thrown in that list are things that, issues that we have run into or could run into. So it basically really wanting to make sure that when this ordinance is amended, that there's certain specific things that get addressed in that ordinance, in addition
And I
to
thought-
anything else that the commission feels.
but
would
I
be-
thought on this list, about half of them were easy,
Yeah,
to me,
more
were
than
easy
half.
answers.
Mm-hmm.
And some of them were hard answers. I mean, I think that, the
Well, so
issue
then
of
I
is,
think we-
if it's destroyed by fire, flood, or act of God, sure, go ahead, rebuild it. If it's something that has, the owner has allowed it to rot away over time, and now they want to rebuild it, that's a different question.
Well,
you
yeah,
know? It
okay.
could
We
be a different question in some cases, right?
Yeah. But I
it
mean-
also becomes, then you sort of have an evidentiary issue. I mean,
Right.
when the
But-
big
but-
rain comes, is it because they didn't maintain it properly that the rain caused it to
Right,
fall in, or
yeah.
was it?
Right.
But
I mean, there's, like I said, there's some that are obvious and there's some that aren't quite as obvious. So,
And when I look at the map of the town, there's some areas where we use the term pre-existing non-conforming lot in the fire department. How did this get to be this way? And, because you get called to somebody's house and you look around like, holy cow. And, so, okay, pre-existing non-conforming. But they were in only smaller areas of the town. They weren't everywhere. I mean, you have huge sections of town that were developed in the 50s, and nothing there is that far out of whack. But there are certain sections of the town, and the canyon being the most notorious, where it would be a difficult decision as to, how do we do it? Because there's not a lot of options. Okay, I don't doubt that that's, and our code, that you are correct, our code, the way it's written now is not helpful. Will not solve any of those problems.
Well, is there a way we can pick off, use this sort of matrix as a guideline to, because in other words, if we were to answer or respond to these issues or questions or things here, we would, and codify them in this new amendment to this ordinance, that would be helpful. So if there's things we can pick off here and discuss and kind of feed into, and then the few things here that are more
Trigger this big thing.
broad or need a look, we can kind of sideline that.
So when you take,
'Cause it's kind of like,
point of clarification, we're talking mostly about structural issues as opposed to
well,
use
it's
issues?
both. It's use, structure, and lot even, right?
Right.
I mean,
Although we don't have a lot.
I know, but those are the three kind of categorical non-conformances,
Right.
that we could potentially face. Use one, structural one, which is height, setback, things like that, and lots, which we may not have a lot of. But those are the categories, right? So we're talking about all three.
Okay.
To a greater or lesser degree. So, if the commercial use nonconformance thing, which has a lot of things tied into it, that one may need to get sidelined. So that, and maybe that kind of gets unraveled in a subcommittee format. But the structural stuff, I think we can.
But you wanna, this is what I envision we do. One is we acknowledge that our current non-conforming code is horrible, and we just pitch it. And then we say,
Which is what we're gonna do.
We're gonna take Pasadena's code and just use that as a base, and we'll change it to fit Sierra Madre. And then we'll take our commercial code as a base, which isn't that great, but at least it's functional. And then we'll say to the subcommittee, take these two and modify them to our general concepts. And then once the subcommittee has that charge, we'll discuss the big policy things right now, and that'll give direction to the subcommittee to revise that code.
I'm just wondering, so let's say we start with Pasadena's non-conforming ordinance, which is good, pretty good. Most of it we could probably just check off and say, fine. I went through and about 80% of it, I'm like, okay.
Yeah.
There's little chunks of it which are a lot more complex to think of how they're gonna work here. But from my point of view, it seems like it would be worth us taking another kind of dip into this Pasadena one and seeing how much of it we can just say, with little tweak, this is fine. And then sort of and see if we can come out the other end of this sooner with something, which we may have to modify again after we come back from the whole commercial zone thing. And I'm just wondering if that's another way to look at it, so you get something more useful sooner
I think it's a good idea, and I think that,
than us souping into the whole big thing first.
and you can get into the other one right after. Once you're done with this one, you can then, because, the general
Because we could
plan
come
does
back and
require
change
that
it a
you
little
go
bit,
into
yeah.
the commercial ordinance as well and make changes, so you could,
I don't think it's
You
gonna
could
take
phase
us
it that
very
way.
long. I really don't. I looked at the whole commercial code. It's not very long. And it's really all about the table of the uses, and then if we want to have design. And I think that one of the issues we're gonna have is if we try to stagger them is, this happens, you do one, and then you do the other one, and you go, oh, I wanted to
Yeah.
to amend that thing. I just figured this out now. And so it's like, you do them at the same time. I think we
What-
get this done in a couple months.
Yeah, I mean, I agree with you, but I kind of like what Gina's saying makes sense to me in the sense of certain issues I think want to get discussed here.
Yeah.
Versus like
Mhm.
the subcommittee met several times, looked this over, and I'm not saying that that's not a transparent process, but to me, it feels like they've gotten together and kind of hashed through the global issues and kind of drilled it down to not necessarily language, but kind of like, we like this, we don't like that it says this. And then when it comes back here, it becomes more of a presentation and not reactionary, but it's kind of like, okay, does that make sense or not, kind of thing. And I think there's some things here like, you know, exactly what Gina brought up, like, okay, I'm okay with, you know, acts of God and being replaced, but like if an owner lets something decay, you know, intentionally, like why should we let them do that? And you know,
We've seen this happen.
I have a different take. I think, you know, there are certain instances where it's not like premeditated, like I'm not going to maintain this. It's just, you know, structures that are 100 years old over time.
Yeah, well, I mean, there's.
Stuff happens, you know.
Here's 3 different instances,
So
but
we should, in those instances, allow that. But that's just a specific thing. But what I'm talking about is there's some things I think we could, if we went through this nonconformance code, and maybe it's just not the use part, but the structure part and the lot part, we can kind of go,
Yeah.
that all makes sense. That all makes
yeah,
sense,
I agree.
okay?
I think we should.
And then the
we should
use
go
part,
through
maybe
this-
we need to, you know,
we
that,
should go through this matrix. That
or the Pasadena, you know, if that's already there,
I mean,
then.
it's linked together.
it is,
The
they're
matrix
the
is.
same kind
Yeah,
of
yeah,
thing.
so we go through that.
Yeah, we should go through that, and I just, the only thing I want to do is, let's not correct any code tonight. Let's just
No, no,
talk
no,
about the
I
policies,
agree, I
and
agree.
then I think that can inform the subcommittee to bring us back a code amendment on the 2 parts.
So we want to go to Exhibit E,
May as well. Is
the
that-
cross-reference matrix, or do you want to go to Exhibit B?
Well, we have to go back and forth, because
Yeah.
that, we should start
D.
with the matrix.
B and E?
Well, there's 2 ways to do it. We could either go through the matrix and go up to the Pasadena code, or we can just go through
Use
the
parking
Pasadena.
Yeah,
Yeah, but it's actually
they kind of just go together, so.
Yeah.
They're,
All right,
I would just start at the top.
yeah.
We're completely
posted
paperless
online.
here.
Or if we have a copy, it's the only copy we have, so.
Yeah.
I don't have an extra copy.
There's a printing moratorium, so we get.
Yeah.
Ah.
All right, well, so this
we can
part,
pick
we're
off.
not going to refer to lots in this part at all? It's not going to be included? That's your,
You can,
T.
it doesn't have to be a long section.
No, I don't
It
think
may
so.
just be a reference as
You
to.
are correct.
Are you thinking we wouldn't have any?
I
mean-
I didn't even read the lot thing, because it's.
I think it's very basic,
It's
but-
not,
Different
it,
thing,
it's
isn't it?
not such a big issue, so I didn't even
Yeah.
focus. I don't know.
that's how I felt about it, too.
Okay.
Mhm.
So then that wouldn't be in it at all.
We have a bazillion of them, don't we? And they just exist.
Yes.
I mean, that's sort of the issue of non-conforming
Well, there's a
lots.
lot of,
There are
it's
a lot of
can
them,
of worms.
And they're here, but
Yeah.
what are we gonna do about it?
Legal existing
Nothing.
non-conforming.
Yeah. They're, I mean, I just think, to me,
I don't
it's
even know
an
if we can
issue,
verify.
but we're not gonna do anything about it, so.
There's some of them so long ago, like.
Yeah, they are what they are, and we do get questions from time to time, oh, I think I have a non-conforming law, and am I gonna be able to, is this an issue for the city? And it isn't, it's a legal lot that's been there, and
Yeah, I mean, I think,
it
to
is what it
me,
is.
the whole issue of lots is like,
Mhm.
not an issue, really.
Yeah, I mean, this issue of like, if the lot was created properly is not really so much of a zoning issue.
Right.
That's more of a legal issue.
Mhm.
The prohibition on further subdivision is, I think it's prohibited in all our codes that says, you know, this is the minimum lot size, so if you're smaller than that, you
can't
can't subdivide anyhow.
Yeah.
So,
Already addressed.
the one issue we have here is if we wanna think of that concept of the lot line, the minor lot line adjustment that we talked about before, doing that on a more global thing than just R1. Because when you have something that says, you know, you can't subdivide unless your lot is X size, or, you know, so wide, or whatever, but then you just want to do a minor lot line adjustment, you know, you've technically prevented them from doing that.
Because of the width,
Right,
length.
and so, to address this in R1, we put it and said, well, but you can do it as long as you don't alter this stuff, and, you know, basically you don't play games with the lot line adjustment. We didn't do that with R3, because we just didn't think it was a big pressing thing, but I don't even know that that's a non-conforming issue as much as it is something we could look at the subdivision code.
I mean, you don't necessarily want people to adjust the lot line if it makes it more non-conforming than it is.
And that would not be approved. I mean, you do have to, you cannot
Well,
increase the degree of
more non-conforming.
nonconformance
But if
by
it's
reducing
a
further.
de minimis amount, I mean, if it's like your lot is too small, but the wall between you and your neighbor is built 1 foot onto your side, you know, you're not making the lot tremendously more non-conforming. It's sort of no big deal. That's the kind of lot line adjustment I'm thinking about. That's really not something that even, I mean,
don't
you
think that
could
would be
address it
addressed
in here, but
in subdivision.
you could address it
Yeah.
another place
Yeah,
more,
I just,
so.
I don't, all right.
All right, so I think we're agreeing, like,
Yeah.
that, to strike that.
So just non-conforming uses and structures?
yeah.
Mhm.
Add a purpose section.
Yeah,
I think
purpose
that's a good
section makes
idea.
sense, yeah.
I thought their purpose section was,
I thought we had one. Let's see, what does Pasadena's look like?
Purpose of chapter.
Purpose of chapter, okay. So I mean,
That-
right off the bat, B, I don't know if do we necessarily agree with that? I mean, I don't think we wanna, or do we? I guess that's the question.
Which,
Generally discourage, it is the overall intent of this chapter to generally discourage the long-term continuance of nonconformities. I think we had talked about, I mean, depends on what the nonconformity is, but in general, like, that's part of the fabric and,
yeah, it is,
I mean,
yeah.
like, is our long-term intent to eradicate that nonconformities? Like,
I don't think we
from-
want a statement like that.
Exactly.
No, I don't,
So either.
I mean, that
I
kind
don't
of
think we
statement,
want to increase nonconformity.
No.
right, but
To
we don't want to
discourage.
eradicate.
Yeah, but I
And-
think,
and-
I mean, to discourage the increase in nonconformity might be the statement we'd be willing to make.
Or we
Maybe.
could just not have a statement.
Mm-hmm.
Well, in terms of not wanting to eradicate a non-conforming use, it's very common provision in codes, and this is policy call for you, that a non-conforming use, which is always disfavored under the law, if it ceases for a certain period of time,
It's gone.
most codes say it's gone, that's
Right.
it. So it's not that you're trying, to try to terminate it, you would do some kind of an amortization schedule.
Right.
And there are some kind of uses that classically, that are become non-conforming, that classically fit that. So for example, when we used to see billboards all over the place and cities started to zone them out, the existing ones became non-conforming uses and signs. And then because there was value in them to the owners, there was an amortization schedule. So that's an example that you're not going to need that level of detail because that's not your issue. But policy issues for you are, okay, you don't want to, it's not your goal to eradicate all non-conforming uses, but then that raises the issue, okay, but if the owner voluntarily abandons them for some period of time, do you want to say that's it? And if you want to say that's it, how long is that period of time? That's one common issue in a non-conforming use that you would deal with. Another issue that's very common is, do you want an existing non-conforming use to ever be expanded?
Right.
That's a very common one. And that doesn't just mean, do you want to expand the footprint of the building, but do you want to make the use bigger, larger?
Right, more intense.
More intense. Is that something you're going to allow or not? Pasadena might allow it with a use permit. Other cities say, no, you just can't do it at all. So that's an issue for the subcommittee to think about when you're thinking. Another issue is whether you're going to allow a substitute non-conforming use. Many cities say, no way. This is the use, and the minute you stop it, that's the end. We're not going to let you bring in another non-conforming use that's different. Yeah.
Yeah, if you tried to.
We allow that under the current code, but that's very hard for staff to figure out because the code's not very good.
Right.
And you've got to try to figure out if the substitute use doesn't in any way intensify or expand the existing non-conforming use. So a lot of codes just say, this is just too much to deal with, too vague, no alternative non-conforming use.
Has to be the same thing.
Yeah.
But what if
I'm
it's
not
the
saying
same
you have to do any of those, but those are your
Right.
threshold issues.
And the issue,
The
I
same
mean,
non-conforming
and
use.
when we think about this, I think,
Mhm.
it's like you were saying earlier, we don't really have use issues in the residential areas. We might have some intensification of use, multifamily and single
Right,
family, except for a few weird examples in the canyon, and those are sort of their own beast that we can deal with when we deal with the canyon zone. It's really just the commercial areas that this is an issue.
For the most part, but there have been instances in residential zones where we've had some weird situations, and if it happened once, it could be repeated, where the code was just not helpful. And one was an example of an accessory structure on property that apparently had been built with a permit, so we knew it was legal use. But over time, and at the time that it was installed or allowed or permitted, it was within an area of the property that later became impermissible because it was within setback. We don't know how it happened. Maybe it was a mistake, but under the record, look, it was a legal non-conforming use by today's standard. And then the accessory building, and this goes to Gina's issue, one could say, well, it was allowed to molder. Others could say, no, it had some termite problems and some weathering. But then the property owner wants to spruce up his property, and he wants to rebuild that structure on the same exact footprint. And then you get into the issue, and our code was just very unhelpful. Well, if it's not a residential structure, you can only do it if it's at least 50%. If it's, at least 50% gone. And that those kinds of regulations, the intent there clearly is to eliminate non-conforming uses and structures unless you have to live in them. That may not be what you want. Right now that's in Sierra Madre's code, and it's really difficult it requires some gymnastics of staff in good faith to try to use the code to interpret, to allow what is, a good use, which is rehabbing something that would otherwise be an eyesore into something nice without taking up any extra space.
Right.
But under our code, we can't do it.
And that's really, again, the whole structural concepts and I think the general consensus is if that's there, we want to let people fix it up. I don't think we want to. I know we did talk about when we amended some of the residential codes that you used to be able to extend a non-conforming setback, and we said no, we don't want to do that anymore. But I don't think want people to, when they rebuild, to then move the building over a building that's been there for 40 years or whatever.
Yeah, my preference would be to, if they want to rebuild it as is in place, the community is already aware and has grown, accustomed to that, but not to expand it. and in any way, and take any actions you can to ameliorate how it's pushing up against existing codes.
And that's a policy level decision that once you've got agreement on this is our approach, you can apply it across the board.
But I think that the clarification on that is, I think from a policy standpoint, we don't want to let them to expand the nonconformity, but the fact that the structure has some nonconformance doesn't mean we wouldn't allow them to expand the structure in a conforming manner. So if they have, you know, that accessory building that sticks into the setback, if they expand it
In the other
more towards
direction.
the middle of the property, I'm perfectly fine with that. I don't think that's a problem.
And we have done it that way. We have interpreted it that way as well. As
Right.
long as it's
You
not on the
can't
side that has the nonconformity.
Right, that's
You can expand, but-
splitting hairs, but in a good way with the intent to.
Right.
I think conceptually we
I could live with
want
that.
to allow, I mean, the general consensus seemed to be like, we want to allow those non-conforming structures to be rehabbed, rebuilt, whatever the case may be, but in no instance do they, if they increase the non-conformity, you know, that becomes a problem.
And you can deal with that in one of two ways. You can simply prohibit it, or you can say, if you want to increase the nonconformity, you need a use permit.
Or you need a variance.
Or a variance if you can get one, but.
Yeah, a lot of times you don't want to.
Yeah.
But I mean, this is digging in the weeds, but Bob, there are instances where I think we want to give the flexibility to allow people, like I know you're saying, like rebuild the structure or whatever, or rehab it in place because the community's used to it, seeing there, and it's in that spot, whatever. But there may be instances where moving it or relocating it actually reduces the nonconformity.
And I'm okay with that.
So we need to allow the flexibility to allow it to be relocated
Yeah, to reduce the
if it
non-
reduces the nonconformity.
Yeah, I
Well,
think-
but a lot of
I don't
times,
think we're gonna argue
especially
about
when you
that.
start to get in the canyon, there's multiple nonconformities, and then it's,
And there's no place to
you
put that.
increase some while you decrease
Yeah,
some.
you
and
open one.
so
And
you-
those are the ones that you would want the commission to look at,
and
you know? I mean,
and-
I think some of them don't know,
right.
because
But
they're so
one
complicated, they
question,
need to have a look.
Terry, you said we review it with a use permit. If we're looking at structures, do we really want to review that with a use permit as opposed to a design permit?
Well, it depends. If you want to allow it at all, so say you have a non-conforming building, which is a little bit of an alien concept for me. It's really use. It's the land use, and that can mean where is the building located on the land, and
Right, yes.
why is that a nonconformity? Like, is it in the setback or whatever? And so at that point, so someone says, well, I want to expand the building, or maybe they have a nonconforming use in a commercial area where, so for example, it's a little cafe. That's not uncommon. A small cafe that's legal nonconforming for some reason, but it's been there for a while, everybody likes it, and now they say, I'd like to put some chairs outside. I'd like to build out my patio. I want to put some, like a trellis over the back patio, and I can move seating outside. Well, then that starts for staff becomes, well, are you not then increasing the nonconformity? Because it was already nonconforming to have a restaurant there, and now you're increasing the size of your restaurant, even though it looks nice, by improving the back with the patio and the trellis. So these are the kinds of, you could either take the position you simply can't do it. You can't increase the footprint of your building to permit an enlargement of your non-conforming use, or you could say, we'd consider letting you do that with either design review or a use permit, whichever one you think would be more appropriate.
But I guess that, that example, the one that pops to mind is Mary's. And I think if Mary's expanded a little bit, probably people wouldn't have any unction with that.
Until they expanded so much, there was absolutely no place to
Right.
park.
I mean, there's just some
That's-
level that
there's that
people
parking
would
thing popping up again.
have. But I guess to me that maybe under law, it's thought of a use issue, but if you have that accessory building on a residential lot that invades the setback,
Right.
that to me doesn't seem usey at all, you know?
Yeah, that's what
I mean,
yeah, I don't look at it as
Yeah.
use.
I think it's
So,
a structure.
That's a structure that's non-conforming, and, you know, whether we allow that to expand, you know, get up, sideways,
Yeah.
whatever, that's a
Well, then
different issue.
that's a good policy call, because right now it's, you're already moving down the right path to kind of throw out the old code, because it's really unhelpful, and look at a new code structure. And so when you're looking at the Pasadena code, Pasadena did it the way they want to do it. But those are your policy, high-level questions is, do you want to eliminate, is it your policy to eliminate non-conforming uses? Are they disfavored, and over time we want to get rid of them? That's one of the statements in Pasadena's code. So you don't want that, and that's okay. You don't have to. And then, you know, like I said, another issue is, if someone abandons it for some period of time, will you let them, like, revive it? Is that all absolutely prohibited, or would you let them revive it if they came in and asked, you know, got a use permit? That's a little.
And this is, that's referring to the use and not the
Mhm.
structure.
Correct, that's
You know,
referring
I
to the
think that-
use.
Yeah.
And I think, you
And
know,
I think it's sort of an interesting, because I think it's a really different idea with the structure than with the building. You know, if we have a list of non-conforming uses, we should have a list that there's some reason we don't want to have them. If it's a list of uses that aren't permitted for some reason, well, then we should be wanting to move in the direction of not having them, because why else do you have the list?
Well, it's not just not having them, but it's limiting them, because to me, it comes back to
Yeah,
intensity.
That was my next
Yeah.
part of the statement,
Yeah.
which is, okay, so why is it, it's the question of, okay, so why is this non-conforming? Is it
Right.
non-conforming for some
Yeah,
reason?
and I think,
And if it's on the list for some reason that we don't care about, then why is it on the list?
right,
Right? You know, I just think that we have to
And
make
we
sure
need
that
to-
the list we have
we need to think
is
about
actually
it.
something that makes
when-
sense.
When we crib Pasadena zoning code, and which is often done much better than ours, but we need to understand that they're a different place than we are, and they actually have a lot of uses that they want to get rid of. You know, they have liquor stores in places that are very concentrated and in bad neighborhoods that shouldn't be there. They have places that are auto-centric and have, you know, auto repair shops and drive-throughs that they want to get rid of and make more pedestrian friendly. Those aren't really issues that plague us.
Yeah.
And so
It's really different.
that's not, I really don't think we have the use that we want to drive out.
I tend to agree, because I don't think, while the ordinance is not a helpful ordinance, I don't see the problem in Sierra Madre as being an insurmountable task. And part of me, I think we need to define, because the way you talked about use as in terms of where a building is sited on a property, and use as to how it's being used, I think we need to make sure that we can distinguish those two, because those are two different kinds of policy. It almost, to me, is what I'm hearing is that it should be an annual event that this commission revisits the list of businesses, because it's changing over time. I mean, 10 years ago when I started, there was some pretty wild stuff on that list, and we've seen it at least once or twice. And now, you know, based on, you know, the difference between a Pilates and a gym, we may want to go back and say, no, we want to parse this out differently. And, you know, beginning tomorrow, there may be some new kind of, you know, business experience that's not on our list, and, you know, we want to keep the code so that it will be helpful, you know, when the people come in the counter today, you know. So you know, those are, so I think we want to look at land use versus use of building, you know, how it's being used. In other words, where it is and how it's affected the code in terms of where it's situated, and then, you know, what's happening inside of it.
Right, yeah, that's also a land use. I mean, what's happening, like the use you're putting the building to. So, I mean, I think that's a great idea, and also people from the community will advise you on these things. As we heard tonight, that Pilates studio with a, you know, we didn't hear the number of square feet, but I'm going to say that John knows it. And although Pilates studio kind of falls under gym and physical fitness, which under our code requires a CUP, and yet a day spa doesn't, and there's nothing for yoga, and there's nothing for like a self-defense or karate or anything like that. We don't know how that would be.
Just wink and look at day spa instead of. I mean, but that's the other
Where
problem
do
to
I
me.
stop?
Is,
Once I start.
when you have a list of uses that's like 40 uses long, and they're splitting hairs in some places, and then there's a whole bunch of uses that came upon since 1965 or whenever this was made that they don't have at all. It just it's pretty not user friendly. I guess.
Well, some cities actually have a category of uses, as we do here, all the gyms and everything, which you like the 24-hour fitness. You're imagining a larger, more intense use, and they'll have that with the CUP. And then they'll have a smaller version of it. The same thing, but limited to not more than blank square feet or more than
many people in the
just permitted. And so that's another way to handle it that would alleviate, would be an easy fix for the person who
Right, and that's what I was
wanted
saying
to.
before. We need to have
So
instead of having
size is part of the
binary,
matrix.
we need to have a
Yeah, it
grid.
can be. It is in some cities, right? Because it is, as John said previously, all about the ability to intensify the use and the impact on the surrounding
I mean,
commercial
you think
enterprises.
that, a law office with one lawyer and a paralegal, is a lot different than one with 50, And
Yeah.
that's just has to do with the size of the space.
Right.
And people are in it.
Other cities, frankly, that want to encourage retail sales tax producing uses will be easier on those and harder on office type uses that produce no resale sales tax. So there's all kinds of different.
Well,
And a lot
although
of those
our general plan now encourages office use other than storefront. I mean, the idea is to, I guess, is to get the storefront open so that it can be retail.
I mean, it's sort of like the residential in the commercial zone behind and above, right?
Right.
It's the same thing with the sort of office use, that it's not on the storefront, it's like.
Your review of the commercial list, that might actually go pretty quickly. And you can, as you're reading through it, you might think you probably will trigger other uses. Well, for example, how does a yoga studio fall in? Because it's not separately listed. How do some of these other things I can think of that are suggested by some of these categories, how would that be? How would that fit? And you can think of whether you believe that we need a full conditional use permit. The real reason for that is to be able to attach conditions. It's discretionary, but that CUP runs with the land. So once it's granted, it's always granted. It's there forever for that property, for that particular use. So that's also a fairly weighty burden.
But it's there for a yoga studio. I mean, that's the thing. If you chop these up into itty bitty little categories, then if somebody wants to do a Pilates, you have to say, well, is a Pilates like a yoga? I mean,
You
instead
have
of
to
having
make that
sort of
determination
more general categories,
Yeah.
or is this retail use, office use,
Right. Staff does have the
What kind of
authority
martial arts
to
do
make a finding that a use that's not specifically listed fits into one of the categories, and they have to do that all the time.
Yeah. But I think this idea of parsing it by general use and intensity of use. So
I agree.
If you have something that has to do with fitness and you expect 10 people or less in the building at one time,
So
that's different than a use where you're going to have 20 to 50.
So you have your finger on something that's going in through my head is intensity driven by square footage or by bodies?
Both.
Well, but I think you really want to do it by square footage because everybody can easily lie about the bodies or the chairs. I mean,
Yeah.
like our parking code for restaurants is by
Chair.
fixed chairs. And so, the game is you put 4 fixed tables, and then, the folding tables come in when you're not looking. And if you just do a
Or
square
the sidewalk
footage-
tables.
Right, and the sidewalk table, no, the sidewalk tables don't need any parking because nobody drives to the sidewalk, right? Yeah. So to me, it's square footage is, you just make your best guess and go with that, because it's so much more easily implemented, and there's less.
And the type of use.
Right.
So when I open my yoga studio, if I can pack them in by square footage
Right.
and they're only this far apart.
You have bunk bed yoga studio,
Yeah, that's a condition. Okay, so where does this put us?
Okay,
I'm just suggesting that going through the list you were talking about, maybe we should do it once a year. I'm just suggesting it may not be as arduous a task as you might think, that there's a common sense factor that the commission can employ. And you've just heard one person say, I'd like to do this, but I can't because I can't afford the $5,400 conditional use permit requirement. And maybe small size, limited spaces don't need a conditional use permit, or maybe they just need a minor conditional use permit, or maybe they're just permitted as a matter of right. But those are decisions you can make.
I mean, there were some things on that list that I thought, why does that require a CUP? It's like, that just seems silly.
Right, and the other issue is, I think, when you look at the list, if you think about that use going into an existing space versus somebody taking a vacant lot and building a building that they're gonna put that on, if you, again, we're talking about the worst case, if you think about the building getting built, a lot of review is gonna be triggered that's really not use-based, but it used to be in our code that we just threw a CUP at something if we didn't know what to do with it. And so a lot of that design issues for the new building should be handled with a design review permit, and the use may or may not require any kind of review.
it's the attitude that they was taken when it was written, because some of it was looked as a defensive position. We're gonna keep, the huge things out or try to control it, whereas now we're looking at how can we encourage? Or how can we allow? And, it's changed over time. All right, so are we still going down the matrix?
Yeah.
Okay.
Okay, so where did we end up? Because we were talking about the purpose. We agreed that there should be one. We don't know if
But not as
this
much.
one's necessarily
Not
on
so much
point.
about discouragement.
Well, but I think.
But we can go through that. That's
But I
not,
think our general discussion of the purpose was helpful, not just for writing purpose, but that's gonna inform
Right,
the code provisions throughout.
because we talked about how do we increase or increase long-term continuance as opposed to discourage or maintain.
Right, and I think that goes into this,
that'll help inform like
like,
vacating.
can
or-
non-conforming uses, structures, and lots be maintained? And I think the answer to that is we wanna say yes.
Yeah.
That doesn't mean we wanna allow them to be expanded.
Yes.
And I guess one of the questions is, as Terry was saying, I think generally we want to say no, but do we always want to say no? Or do we want to say, well, maybe, but we want to review?
Right, do you want an escape clause, which would
Yes.
be your design review or your conditional use permit or whatever you want to do it, instead of just outright prohibiting any change or expansion of a non-conforming use? And that's a policy level decision. Pasadena actually does do that. They have a provision for alteration or enlargement of a non-conforming structure and alteration or enlargement of a non-conforming use that you might be able to do it, but it needs a permit.
Now, under our current code, or if our code were silent on nonconformance, and somebody had, the proverbial accessory structure that was in the setback, and they wanted to expand that in a non-conforming way, like expand into the
setback?
into the not setback.
Follow
Into-
current
Oh, the other way.
That would be something we would allow, right?
I think that on that hypothetical, I think that we would, if they could get a building permit for it, or if the structure, the accessory structure, they were trying to, build out a little more into the yard, away from the side yard or the setback, still didn't exceed more than the 120 square feet, maybe they wouldn't even be asking us. They'd probably just be doing it.
Right.
Well, but let's assume they had to get a permit.
Yeah, okay, so they need a building permit. Yeah, if they could, if it didn't harm any of the current zoning code for the part they're expanding into, we would probably allow it, because they're not, it's splitting hairs a little bit, but they're not increasing the degree of nonconformity. The other thing that we could do, and this is a policy call, if someone comes in and says, hey, I want to expand my building this way, and we don't have a nonconforming ordinance, we'd say, well, you can't do that. In fact, you have to remove the whole thing. That's, where can you prove to me that that was legal? And then they'd have to be able to show that they had authorization to put it there at some point in time. Like, could they show that it was there, for example, 20 years ago, and then they can go back in the code and say, hey, 20 years ago, this isn't where the setback was. So that's a burden they would have to have if we had no legal nonconforming.
But
I'm thinking of, I mean, along this line of trying to, let's say you're tearing down the thing and you want to rebuild it to the
Yeah.
same level of nonconformance. And I'm thinking of things that have been built that caused us to change the rules because they were so
Yes.
egregious. But when it was built, it was conforming. Now it's non-conforming. And under certain, under a decision we might make, if something happened to that building, or if they want to tear it down and rebuild it, they could rebuild it at that same level non-conforming, which we really would not want them to do, because that's why we changed that rule,
Right.
And I'm thinking that's something that we would want to avoid. There are conditions where things have been built that were really egregious, and we don't want that happening again.
Right. Well, the
And
other
so
thing is,
Which one?
is if you,
That's the house. There's two of them next door on Highland.
Oh, well, yeah, those were,
There they are.
right.
They were
but
built with
if you,
open porches.
right.
if you
That later
have an
grew windows.
existing structure that's, like, say, a wooden structure
That's why I keep it.
weathered and sort of blended in, and they want to replace the exact same footprint, but they're going to do it with some sort of materials that are much more visible and perhaps
Hideous.
hideous.
Say.
Okay. It's just they're just straight CMU or something, right? That's the kind of thing where maybe you do. It's not the case that you're objecting to the building itself, but the design issues that go around it, you are.
Yeah, but I mean, there's some where you would be objecting to the building itself. I mean, say someone comes in and wants to tear that building down and build a new, much bigger building, and the other side of it is conforming, but they want to keep the non-conforming side, right?
Or there's this,
And I think that I would really not want to see happen. And I could
Right.
see that kind of loophole being used by someone.
right, or square footage. I mean, if
Yes.
you have a house that's too big
Yes.
and it was allowed for whatever reason before, and they come back and they want to do something to it.
We don't want those things to happen,
Well,
that we
that's
change
your
the law to
issue of-
prevent.
That's your issue of not permitting the expansion of a legal nonconforming use or a legal nonconforming structure. So when we say use, we really mean intensity.
But beyond expansion, if somebody has a house that's bigger than the floor area that we would allow now, and they want to tear it down and replace it in kind, not because of a calamity
No, just
or
'cause
act
they
of
don't
God, just
like it.
because it's old
Voluntarily.
and instead of fixing it up, they just want to tear it down to the foundation and rebuild. Do you want to review it?
I would not want it to be permitted by right.
So
If
you
it's
do want to,
non-conforming,
then
yes.
you do want to.
Yes.
So I mean, I guess one other
I
question
would
is,
want to
could we
review it.
could we?
There's things we would not want to permit to be built in the same way.
And that's in that list.
Right.
several of these items you're discussing
Yeah.
is in this list
Mhm.
that's being recommended for, to be addressed.
Right.
Yeah, that's what Gina is raising the issue of. I think everyone agrees, well, it's in most codes, including ours, that if that structure that was in your hypothetical, this big, not, legal but non-conforming structure is destroyed by fire, they don't, they can rebuild it. But they have to rebuild it on the same footprint. And if you want, if you wanted to, I don't know that it's necessarily good because you might not have liked it in the first place. You could say with similar materials, but that
might
is
have
a
been
two-edged sword. Yeah. Then the next level is, well, yeah, but they can maintain it and repair it. Sure, of course. We don't want it falling apart and moldering. So yeah, you can do that. Okay. What if I want to change it? I don't like the way it looks anymore. I just want to tear it down. It's not any
Act
kind of
of God.
casualty. It's not an act of God. Nothing. I want to tear it down. I want to build something else new. In the same footprint. Can I do it? And
No.
that
I say no to
that's
that.
an issue. And a lot of cities say no.
That has been our
But that's a policy
Good.
call.
I don't think the answer would be no.
It's not written in there.
I think the
No.
answer,
No, it'd be I mean, I'm saying no, it had to be reviewed.
no, it had to be
Or do you
reviewed.
do you want to say, right, that it's not, that it's
not by
prohibited,
right.
but it's not by right,
No, not by right, but
and
it's,
you need a permit for that?
it might be allowed, but we want to review.
Yeah, I mean, I'm
Yeah.
saying, no, you can't just go back and build it, if it would be non-conforming to build it that way.
Well, what a
now.
lot of cities would say is, if you want to tear down what you've got and rebuild the same thing there, the answer is no, you've got to conform to today's zoning code. So that might be a smaller structure.
Well, yeah, but I
mean-
would much rather be in the land of, I would rather review it. I think
Mhm,
about,
okay.
especially in the canyon, if we got into the thing where
Oh,
you know,
couldn't build anything.
Oh,
cottages in the canyon are getting old and somebody decides, I want to replace this thing, and we're gonna say, no, I don't think we
No,
want to
no,
go
I mean,
there.
my no was, no, you can't
Right.
build it by right.
Right.
But I think that.
Then you
that-
want an escape valve. That's
Right.
kind of what I'm hearing. You want to allow the possibility of someone expanding a legal nonconforming use or structure, but they would need a permit to do it.
But I think, I just think that if someone, especially just in the R, in R1, say, someone wants to tear down,
I think there'd be I think there would be, if you give that example, that this is a choice, and the lot size and the setbacks and the neighbors are, it could be done, then we would like to review it, but it's not an absolute no.
yeah.
But if they want to choose to tear it down and then, then the building is already non-compliant, even though it's legal, we want to review it.
Then you come to the question of what is tearing it down, right? What's the percentage of the building that has to be gone? That's in the
Yeah.
Pasadena code.
As opposed to the rehab or,
I mean, in their code, it's something about how much it costs, but to me, it's much more about the percentage of the structure.
But is it really percentage of the structure or is percentage of the non-conforming part?
Well, yeah.
'Cause, I mean, if you-
It's about the mass of the building, not the cost of the building, as far as I'm concerned.
But I think we also need to split hairs a little bit and figure out, like, from Gina, your point of view, like, it sounds like, like, we're gonna have cases where it's a primary structure versus an accessory structure or a back unit or something else that subordinate structure may be non-conforming, and they may want to rebuild that, and it may be like a garage or something, and then we're gonna put the same level of scrutiny, like that if it was the main primary dwelling or the house or whatever that's in a setback, that we want to see that because that's street facing, that's on the block versus
Yeah.
there's some instances where it's a smaller structure that's non-conforming. Do we want to put them through a full design review because we want
That's
to?
why we have administrative design.
Right.
review.
Well, that's the
I
thing.
think
I think we've
here's
got to
the difference.
discuss,
Here's
like,
the
there's some cases where, like, okay, you're going to let them put it back the same footprint, size, whatever, and it's a garage, you know,
I
like
mean,
they
say it's a
can't.
garage on the property line. We have dozens, if not hundreds of these in Sierra Madre. The garage is built on
I
the
own one.
property line. It's
I own
like-
two, actually.
Yeah, I mean, and it's a one-story, you know, two-car garage. It's, something like that is not the same as a two-story house addition that's built 2 feet from the next house, right? I mean, it's a matter of intensity and impact it has on the neighbors. And so there is a, I agree, there's a difference.
Yeah, and I think
There's a-
we will
There's
need
definitely
to,
a spectrum of impact.
because in my opinion, I think there are some non-conforming items that I don't think need the same level of scrutiny or review to sort of allow them, you know, I don't think they should be totally like, well, just go
So
and do what you want, but
then
kind
how
of
do,
thing.
then how do we
Because it-
split that box where
You make
where
it-
part of it is
I
a
think it goes to
chart,
what
just
John's
like-
saying.
chart? I agree.
Yeah, there's gonna be a matrix of some sort that says, you know, if it's
Okay.
X, or if it's in the rear of the property, or if it's, you know, or if it's non-conformance is solely like a setback issue, or
Or if it's a second story
size
versus
issue.
a first story.
you know,
Say.
I think we need to allow,
I mean, that has a lot more impact on the neighbors than a first story.
because I mean, frankly, like the structural non-conformance for the most part are gonna be R1 or residential dwellings, like garages or accessories or things like that that are out of whack.
mean, the most
Or they were fine 50 years ago, but you know, that structure is 100 years old, and in 2017, like it, you know, we've got bigger rear yard setbacks, you know, and back then maybe, you know, they probably didn't even have fences between, you know, boundaries, and these things got put where they are. But my point is,
There was no
we need to look at it like, in those cases, are we okay? Like, there's only so many ways they can re-put that puzzle back together. Do we want to like be like, we need to open this thing up kind of thing, you know? And I think
there's a certain
there's
amount
some-
of review that we've got to do some sort of gradation, because
Yeah.
an accessory structure, especially if it's one story, I don't think you want the same level of review. I think also if you know, we talk about the garages on the property line, a lot of times, you know, garages were built smaller than they are today. And
Yeah.
so if you're going to ask somebody to build it right on the same footprint, it might not comply with the requirements for a garage. And so they're going to want to expand it a little bit. And I don't think you're going to want to say, no, you know, you've got a garage that's 2 feet too small, and so you're just screwed.
yeah.
And that, there needs to be some level of escape clause for that. Let me ask you a question on nonconformance. If the property under that is faced our current zoning code, and they got a variance to build it, and then they build it, is that a non-conforming structure, or does the variance make it conforming?
Permitted, it's not that it's not conforming, it's a variance from what, because that was the only way they could use their unique property to get, or whatever the situation was, to get the same level or right of use that everybody around them has. So that's not considered the same as a legal non-conforming use, but
So if
yeah,
the-
it is legal.
So, but my point is, if at some point we granted them a variance,
Right.
and then the house is old or whatever, and they want to demo it and build it back on the exact same footprint, the variance runs with the land. They can do that without coming back, right?
If the variance runs with the land, then yes.
Does it? I mean,
That's the question. I know a conditional use permit does.
I don't know.
I would think so, because that's the whole point of a variance, is there's something about your land that you can't change, that means that you cannot get the same right of use that everybody else in your area does. So yeah, the variance runs with the land, so they would be able to.
But then it becomes an evidentiary issue of finding that variance, and
Right.
if it's a cabin that was built 100 years ago, we're probably not going to find any
There probably
permits
wasn't
at
a
all.
variance. There
Yeah, it was a
wasn't permit,
handshake.
There wasn't anything.
It was a
It's just there.
handshake.
There's a handshake, right?
That's why
Here's
it's
your
called
variance.
Looks good.
existing non-conforming.
Looks good, Bob. Build it up. Okay.
Okay, are we working our way down the code, the list?
So I think we all agree on if it's demolished involuntarily,
Mm-hmm,
we want to let them rebuild,
yes.
Yes.
right?
If a structure is demolished involuntarily, can it be restored while maintaining the same nonconformance?
That's what we were just talking about,
Yeah,
right?
that,
Okay.
yeah.
And I think that one is,
Voluntarily, right?
if it's voluntarily,
Involuntary.
Oh,
involuntarily, we want to let them build it back.
Yeah.
If
Yes.
it's voluntary, we want to
Review.
review.
In
And
not,
we don't
maybe
know
not
what-
in every case, but,
we don't know, maybe not in every case in what level.
and that
Right.
needs that needs discussion.
Right.
Okay.
Involuntarily, if it's, gets knocked down by
So,
wind.
next one, changes to non-conforming structure. Should a non-conforming structure be allowed to be enlarged or structurally altered as long as the expansion complies with current applicable code requirements and providing that it does not increase the degree of non-conformance?
I think that's one that we just want to allow. right?
Yes.
Which one is this? Where are we looking?
That's what I heard.
Which one are you looking at?
That's,
Where it's 1771-040 to 1771-080.
where
Oh,
the,
changes to non-conforming.
where the structure invades the setback and they enlarge it the other
The
direction.
way,
Mm-hmm.
right.
Yeah, I think that's a yes.
They comply with current codes with their rebuilding,
Alteration or addition.
alteration.
They're not making it.
And we want to encourage people to
bigger or-
comply with existing codes.
But if they expand it in a non-conforming manner,
We don't
Then
want,
they're-
So
we don't want to increase the degree of
Do we want to see it,
non-conformity.
or do we want to say no?
We cannot
Yeah, that's the question.
increase- I don't want to increase the nonconformity.
what
Do we wanna see it,
Say
or-
never, or do you want to say
That's true.
we have an escape clause that will review it?
There could be some, there could be something.
Well, that's like I think the perfect case is the garage on the property
Yeah.
line that's undersized and you want to expand it 2 feet each direction. Well,
In 2 feet in 3
You're
directions.
still gonna be in
It's
the,
on the property line on
Yeah.
two directions. And one of those directions is going to be on the property line.
Even
So,
more,
yeah,
so, yeah.
and so you're going to increase the nonconformity.
Right, yeah.
But if you're going to build a garage to code, you need to make it bigger.
I-
yeah.
Well, in which case you might have to,
Come and see us.
yeah.
Well,
that's what I agree.
The question is, do you want to say, no, demo it and move the whole dang garage?
So you'd have to come see us.
Or do you want to say, come and see us?
Come and see
You'd
us.
have to come see us.
Just
It
so,
might be
just
okay, but it might not be okay.
as a reminder, in the R1 code, there is a provision if you're, if you're continuing an existing nonconforming setback
Mm-hmm.
on a primary structure, there is a minor CUP process, which now is an administrative review.
Right.
So it doesn't come here for a primary structure, but what I'm hearing is for a accessory structure, you would like
But
to
it's
see
a
it.
limited
Oh, well,
amount, isn't it?
we're saying, I don't think
Some
we're,
type of
we're
review.
fixing the level of review.
You're
I
saying
think
some
in
type of
that,
review,
in
yeah.
that concept where you're talking about a garage expanding 2 feet, I don't
I think
think
it-
we want a full
Yeah.
planning
Yeah,
commission.
I mean, it would be
You're talking
backwards.
about some type of review.
Yeah, I
Right.
think it
Not
would be,
necessarily you,
Yeah.
when you say, I want to see it,
But
it
someone
doesn't
needs
mean
Well,
that
no,
you
no.
want to see it.
we want to see
Okay,
it.
just wanted to make sure.
Because, I
As
mean,
opposed to saying no, we want to be able
Don't
to
take me literally,
review it.
right?
Okay.
But I mean, that case that you were just
I mean, that's a good
mentioning,
example.
there's a limit on how many feet, isn't there?
No.
It's just forever, they can just continue the,
Well, not forever. They
Good.
had
I
a
have house
property.
on them.
yeah. but I mean
Until
the
they hit
entire-
another setback. Until they hit, say, the rear
front
setback, and then
Till
that's
they
a different story.
hit oil.
So,
But
okay.
That's a perfect example. I think there you wouldn't, that would be, if anything, it should be backwards, right? Like in that case, I think the accessory or subordinate structure
Right.
should be the same level of review,
Yeah.
as a primary.
Right.
So next one, do we want to establish certain alterations that are allowed, such as seismic upgrades, building code upgrades, to comply with earthquake and building code safety standards and voluntary code upgrades? Also allow alternates to eliminate nonconformity? I would say yes.
Yes, that's an easy yes.
You know,
But to a certain degree, I mean, the problem is you sort of build a loophole that, oh, I'm doing this for,
True.
X, and then,
Well, I would say that doesn't increase the mass and volume of the building.
And it's not bringing, it's making it, at the end of the day, the building is more in conformity with existing
Building
codes.
code, but
well, I mean.
They're
it's-
going in the right
it's-
direction.
But it's one thing, is like, if you're gonna, in building code safety standards.
Yeah.
So, if you increase the height of the chimney, because we have a lot of chimneys that are non-conforming because they're not high enough up.
Correct.
And so if somebody wants to raise up the chimney, and then we have one provision we just added where you can't do that too much, so then you're gonna run into another code. I'm just saying that I think there's loopholes in here.
Yeah,
We
there
need to be sort of careful about.
I think it says establish that certain alterations are allowed, so it doesn't say all alterations. I mean, it's gonna be dependent on what you're doing.
Yeah.
Like, if you come in and say, you know, I need in order to seismically retrofit this thing, I need to make it larger and higher and bigger, like, then.
That doesn't make sense.
That doesn't make, I mean, like,
Yeah.
there's gotta be
Maybe you
some
wanna
rationale,
put in a new foundation,
which,
Yeah, you can
yeah,
imagine-
which might raise the building up a little
Yeah.
bit. but
Or
yeah.
expand, if you're putting in sort of buttressing things, or, I mean, you could
and
expand
in
the size
general,
a little
like,
bit.
in general, if you look at it in context of older structures, like, anytime you're gonna go towards being in compliance with current building code, structures generally gonna be larger.
But how much larger?
Well, I mean, it's not 10 times bigger, but it might be a 2 times, like, you know, if you had to rebuild your roof or walls, you know, like, there are structures in town that have no walls.
Careful,
Okay.
careful,
Right?
careful. We had this fight already.
But I mean, what I'm saying is, like, if you gotta put in a stud wall, that's 4 inches, right? Like, everything gets larger,
Right.
you know, when you go to the building code, to current code, because stuff built back then was probably like paper thin, you know, so that was that whole argument.
What I'm saying is, we don't want to increase this, we don't want to.
The footprint, yeah.
Materially increase the footprint
Yeah.
of the building.
Which I
or
think
the
would be
height of it,
fine, which would be that,
You know?
well, that one I would disagree with only because it's like that roof situation
well,
over at
I said
Montecito,
materially.
right?
I put
Because,
that word
Right.
in.
well, I mean, yeah, like, if you wanna go 10 feet, you know, that's,
You wanna
okay,
go
well,
5
uh,
feet? No, you wanna go 1 foot, yeah.
but I
wanna
think
go
that's
3 feet, I don't
something that can, you know, you wanna look at or not look at.
Okay.
but I think we should allow it. In
Allow it.
concept, I think we should allow that, because it's a benefit. I mean, if we're talking about structures,
But they could be.
Residential
forced to
structures.
Increase the width of the walls going in, not out.
I mean, yeah,
Yeah, but if you got a lot of built-ins or something, you wouldn't.
I'm just saying.
Well, we're not talking about materially making it bigger, we're just talking about making it bigger because of the code requirements. So if the code requires now you know, 4 inches instead of 2 inches, yeah, it's gonna get bigger. But you're not taking advantage of the code to put on 2 feet.
no. I
So-
think it'd have
I
to
mean, that's
be
what I'm talking about,
within,
but-
within certain
So
limits.
you know,
could be
can
precise.
staff make that?
Well,
I think
we-
they
I think
easily
we-
could make
I
that
think
call.
we understand the policy we're talking about. We
Yeah.
wanna allow this of right
Yes.
within a certain reason, and we can work on the code that does that.
I mean, I think common sense kicks in, like,
Okay.
if
But,
someone's
you
going
know,
5
there'll be
feet,
People trying to.
Vacation of non-conforming use. Should a non-conforming use that vacates voluntarily or involuntarily be allowed to be replaced by the same non-conforming use regardless of intensity? And if so, should a vacation time limit be established?
How is it involuntary? Is that the building burns down?
I'll say that the landlord
Evicts you.
I'd like you to vacate at some point, you know, your lease is gonna be over and I don't want you to renew. That,
Excuse me, could be an event where you have to leave.
Well,
I don't want a tarot reader.
I think
I don't think it's allowed in Sierra Madre anyway.
I think,
Right, but that would be
I
the
don't
case.
know about, I don't think the issue of voluntary or involuntary really makes a difference here, because it's generally, it's economic issues, right? And that, you can say those are voluntary, but often people aren't doing it.
Well, what do people think about? What's the answer to this? What do you think? I'm like, I don't know.
I think we wanna allow them, I think we wanna discontinue it if the use goes begging for quite a long time, but I wouldn't make the interim really short.
well, I mean, that concept is tied directly conceptually, if we are pro non-conformance, like, we're okay with that.
To me, it
We're not in the
depends on
business of
use.
discouraging it, so then, but if we have a concept of vacation or vacating a use, you want those time limits to be prolonged.
Yeah,
as
but.
opposed to shortened.
But I think one of the things is we've said, we're pretty good with how things are now. But I don't want someone going hunting and saying, oh, this place used to, 20 years ago, this used to be a pig farm, you know, or whatever. You know, all the
Rifle range.
We
horrendous
have an
noxious
example of
uses
this.
that you don't want.
The Highlander, right? The liquor store that was there. They lost their liquor license. And
That's a perfect example.
that's it, they lost their
Yes.
liquor license, they weren't allowed to reopen as a liquor store because liquor stores are not permitted.
That's right, in most cities, that's your classic example
There's your
of
example.
getting rid of a legal non-conforming use is a liquor store that's legal and non-conforming, and they lose their liquor license for some period of time, which equates with whatever the ordinance said was, you know, it could
they
be as
weren't
little as 90 days. It depends on how harsh the ordinance is, and then that's it.
Well, I think that one of the things is intervening use. You know, is this perfect, say, the Highlander, that there's a new use there, right? So I don't want it to revert back to a
Right.
liquor store.
Yeah,
But I don't want to make the time limit too short because, you know, you can have uses, especially in an economic downturn, that go vacant for quite a while. And you can spend hundreds of thousands of dollars building out a restaurant. And then if you're not going to allow a restaurant to go back in there, it seems like a horrendous waste.
So you have a restaurant, it goes dark for whatever reason, it can come back as a restaurant. So you're gonna tie it to its last
Assuming
use?
it's non-conforming. I mean,
Yeah.
how was that,
Right.
I mean,
There's no
it
CUP.
depends
or-
on how it's, to me, it depends on what it was and how it was non-conforming. If it was something like a liquor store, which does have hazards attached to it, which you may really not wanna have, you maybe didn't want that to come back. If it's something like a restaurant, which is coming back as the same thing. I mean, I'm just saying there could be
So-
situations where
so-
you really, it's non-conforming and it's a reason that it's not permitted.
So
by
I would look at it as a minor or some kind of administrative review because the other things might have changed in the interim. Because you go back to you, how long was it dormant? Well, in the time, there are other kinds of code changes that if you're gonna bring it back, if you're gonna come back, you know, let's at least bring it up to the safety codes.
Yeah, well, I think it should be something like 2 years.
Pasadena
What is
does
Pasadena?
12 months.
Well-
Yeah, I think we should be a little longer than Pasadena, but I don't think 5, 10, anything like that. Where conditions are gonna drastically change, but I think if a liquor store, you know, if the bottle shop changed ownership for some reason and closed down for 13 months, I wouldn't think, oh God, we gotta get rid of the bottle shop, you know, I think that would be fine.
2 years, but also you tied it to the last use.
Yeah,
Mm-hmm.
yeah.
So
I
those
think-
are two kinds of, those are two,
That's right. Sometimes it's not that all use ceases for 24 months, but that the legal non-conforming use suddenly changes to a permitted conforming use
And then they want to
for
bring
some
back
period of
the
time, and then
non-conforming.
somebody wants to bring back the prior legal non-conforming use and says, well, why can't I? And that's,
Where the time frame comes.
yes,
Mm-hmm.
that's another example of abandoning a legal non-conforming use.
Right,
Is
and
if
you
you
could see-
substitute a conforming use for
Right,
it.
if, you know, the owner of Mary's Market didn't wanna run the store/restaurant and just live there,
Yeah,
you know, and shut it down, at some point you'd say, well, okay, too bad, or not, because that's special, but, but you know, if they did that, if they just shut down the restaurant for a while because whatever, health reasons or something, you don't wanna say, no, you can't have a restaurant there.
I'm okay with that, especially if you tie it with its last use.
Right.
It's that, it's that when you have to go back in time to figure out, oh, this used to be a, you know, rifle range, I want to bring it back, then, you know, I have problems.
Right, and I think that,
But that 2-year thing is gonna kick in, right?
right, and I think, I've
Wouldn't
seen
have to go
18
fast.
months in a lot of cities, and,
Yeah.
but I
You wouldn't
think
have to go
we wanna
further
be a
than 2
little
years.
longer.
well, probably the easiest way you can, well, actually, there's lots of different ways, but one way is just to have, you could have a provision that says the following are, you know, your legal non-conforming use can terminate, by the following, any of the following actions, and, you know, abandonment for 18 or 24 months, or intervening, legal conforming, legal use or conforming use exceeding 18 to 24, you know, you could still tie it to the same time period. So once a conforming use comes in to replace it, if you still want to provide for the opportunity that the conforming use doesn't last within that 18 to 24-month period, do you want it to revert back? That's a policy, I mean, a call for you. And so you could list those as the various ways a legal nonconforming use can terminate. That Pasadena does that.
Right.
And they have a list, but their list is, well, if you violate any law, that's pretty broad. If you change from one non-conforming use to another non-conforming use, they don't want you to do that. But our code, for example, says you can, our current code says you can change from one non-conforming use to another non-conforming use as long as the one that you're changing to is decreases the non-conformity. It just can't, so that's another, it gets really complicated, and that's why I tried to start with a high-level policy
I think that
discussion.
the issue there is sort of, one, to look at it in two different places. One is outside the downtown and then inside the downtown. And outside the downtown, except for, Mary's Market, which I really think we need to do some work on the canyon zone to allow that, and it talks about that in the general plan. We don't have uses so much outside that we care about. So I don't see that, preserving those really well is important. In the commercial zone, I think this whole tiered concept is really better addressed by really looking at the matrix of uses. Because the matrix of, or the tiered intensity thing gets pretty subjective. Is a yoga studio more intense than a Pilates, right? Good luck, staff. And so I think if you just have a matrix of uses that's more reasonable and allows for adaptive reuse, that those are gonna not be as big of problems.
So do you have enough to proceed on that?
I thought you guys were gonna form a subcommittee.
That's a subcommittee.
Oh, okay, well, I got subcommittee, but we're
thought
wailing away on the policy here.
That's a subcommittee thing.
Well, maybe that's a subcommittee one, yeah.
I mean, I'm just thinking about,
The subcommittee
say,
should do just all of it, because if we start cutting it into bits,
Yeah.
and then when we put it back, it's so much easier just to do it in one big chunk.
I'm
Okay.
still thinking about, are there some existing legal non-conforming uses that we really wouldn't want to continue in that location? I mean, I'm not thinking of something now, but to me could be possible that maybe we don't want, I don't know, as many mechanics in this, or something, or some other thing that is something of a nuisance. I'm not,
Well, we have
but I'm just thinking.
agricultural uses in residential areas, and they might even have some production kind of stuff, processing. But I don't think people see that as a negative. I mean, it's like, there's some more intensive agricultural uses that people that have more nuisance value that I don't think we really have. Well, no, cows.
We're making marmalade in one
Yeah,
section.
Right, that's what I'm saying. Keeping a marmalade, I think that adds
And I'm just-
interest and uniqueness. We don't.
I just don't want to sort of have something in the code that sort of would encourage or continue to allow something that
We don't want.
we don't want, yeah. I mean, I'm not thinking of an example, but it seems like
Well, there are some
a
uses.
certainly possibility of that happening.
There are some
That,
uses
that, if it's non-conforming, we should have a reason that it's non-conforming. If something is not permitted, there should be some reason that we don't want it. And if it's on the list that it's non-conforming, well, there should be some reason for it. And so if it changes out, we should be able to say no. And if there isn't a reason that it's non-conforming, well, why the heck is it on that list? And we should just allow it.
Right, well,
And I think that's the problem I see,
I
that
agree.
either we don't want it or we do want it.
And that's
it's
why
like-
I think
and
we need to look at the
that's-
list of uses in the
And I
commercial
think
zone.
that to kind of say, oh,
And
we don't
look
want
at
it,
it
but
in
we do
terms of
want it. No,
intensity
we don't
as
want it,
well
we
as
don't want it.
permitting in CUP.
Right.
And
this seems like a problem, that would come
Well,
to
in
the
a
county.
very real sense, legal non-conforming uses are actually created by the city, because it's a use that was legal at one time, and then the city changes something.
right.
Right.
So that's another way to approach it. So if there, so that's why they became legal nonconforming. At some point in time, the city general
Changed
plan
its
update
mind.
or whatever looked at this and said, well, we don't want this type of growth or area here. So,
So if we're saying we don't want it, then we don't want it, we should do something about it. And if we're saying, we say we don't want it, but we really do want it, then we should stop saying we don't want it.
Right, and that's why I think if you look at the
I think
residential
that's-
areas, we don't, I think there's some uses that state law makes us allow that we would do away with if
Right.
we could, but too
Yeah.
bad we can't. Other than that, I don't think we have non-conforming uses in the so it's really just, it gets down to the list of uses in commercial, and then someday we'll fix East Montecito.
Okay, in the case of a single-family residence, if a family use has become non-conforming due to a change in the underlying zoning designation, can a single-family residence be restored after being replaced with a non-residential use for the same period of time? Woo,
So,
I need an example.
Is that the
is this
house?
like the house behind Panatorium?
How about the house that's,
It could be.
Like, cause that's a
It could
residential,
be. Let's say that it was used for commercial purpose for a while.
that was a house.
that house?
Say that it,
Yeah.
for example, if it is used,
Lunch.
it ceases
Like a
being used as a
salon or
single-family
something.
room.
That was a house.
Right, and becomes something else,
Yeah.
and can it revert back
Okay,
to a
so-
single-family
So
residential?
you're
Yes.
saying,
Yeah,
okay,
Let's say they
I
wanted
mean,
to
that's a
have
prime
that
Yeah.
example.
Wait, what were you saying? We were.
Well, it's like that house that's in commercial behind the dry cleaner.
right, and
Right.
that's a house now.
It's a house
And
now.
so if it got converted to
To
an
a hair
office,
salon or something. let's
which
say.
is what happened to lunch, right?
Yes.
Lunch
Yes.
salon. Can lunch go back to
Being
A
a
residence.
residence? And my answer to that is 2 years, same as the other.
See, I mean, my answer would have been it's location based to some extent. Like, to me, lunch, that would be really odd if that turned into,
because it's in a,
residential.
it's,
because it's right smack dab in the middle of, right there. But the one behind the dry cleaner,
it's on the edge.
it's on the edge.
And
It's,
who cares?
you know,
But
so it's,
I don't think that's best addressed by non-conforming. I think, as Gina was saying, that's a problem with our zoning code.
Mm-hmm.
And I think we need to look at the uses, and one of the things we don't have in our commercial code that we used to was a mixed-use ordinance that talked about where the res went, and we threw it out because parts were not compliant with Measure V, instead of just amending those parts.
Yeah, I mean,
Um,
that
but-
house really should be residential professional, right? So it could be either
period,
one.
yeah.
So,
Yeah.
I mean,
Should be
maybe.
That, so that is a zoning
It
issue.
should be
But like lunch, like you wouldn't want that to,
Right.
in 2 years to revert back
To
to,
a house.
to a
Well,
house.
But it's
been more than 2
it's
years.
been
I
more
mean,
than
It's
yeah.
been a long time.
So, but I think, we've talked about the way mixed use happens in the commercial, it's above or behind.
Mm-hmm.
Maybe it's not above or behind, maybe it's just not fronting Sierra Madre Boulevard or Baldwin. Because if it's on one of those side streets, that's sort of behind, even though it's not behind on the lot. And maybe that's the right way to think about
Because, I
it.
mean, that house, it has residential on the other side of it.
Totally.
Right,
And there's another one on the other side of the street that's the same, which has, it's got the B of A on one side, it's got
Mhm.
another little house
Yeah.
on the other side, and,
Yep.
and there's no reason why that, in any logical way, there's no reason why you couldn't say, well, that could be residential, or it could be business, it fits in either way.
right. And so that's
And
why
I
I
think
think you
it's-
fix that with the zoning code, not with the non-conforming.
Okay.
Because it is zoned commercial.
Right.
The one behind Pentorium is zoned
Zone
commercial.
commercial, yeah.
Yeah, but it's
And
kind
it
of,
was confirmed that way through the general plan update
Right.
process.
yeah,
it
but it's a bit
was-
silly, because it's being used as a house, and,
But residential use is allowed, it's just,
yeah,
it's not allowed
on the main
on-
drag.
well, currently,
It
because
is.
we don't have a mixed-use ordinance,
Yeah,
we just default to the general plan that says it has to be above or behind, or not
Oh.
just the storefront. And so I think if you say, well, what we really mean by that is on the boulevard or on Baldwin, then it's conforming.
So how would you answer this? Would you say yes, but it'd be like a 2-year?
I would say 2 years, but I don't think we have any instances of that except for that one, which we can
I don't
fix.
think it was ever.
Is that literally only, I mean, I gotta think.
Well, there's also the one behind the sanctuary. That's zone,
Oh.
will be zone commercial very soon.
Where?
On,
SMC.
South
Hermosa.
Hermosa and
Oh,
Mariposa.
that
Across the
one
park.
that's that little, it belongs to the church.
Right over here, yeah.
that's also now zone commercial. We will be, once we put those two maps together, but the land use was changed to commercial.
Yeah, I missed that building,
So-
so I had a different opinion about it at the
Which,
time.
where?
It's
I
the
was sick
corner
or
of
something.
South Hermosa and Mariposa.
On the same side as the church,
South
Yeah.
of the sanctuary, the.
It's just south of the.
across the street from the
Corner.
park.
Oh, yeah. So
that
I
little house
think that
that's,
if we change the code that way, it would allow that one as well, which I don't think is a problem.
You're talking about 2 years, though. If,
No, I'm saying I
You-
think we should just say you can't have res on the ground floor fronting Sierra Madre Boulevard or Baldwin.
But anywhere else in a
But
commercial
anywhere else in the
zone.
commercial, you
It
can't.
could be
So
residential.
it has to be above or behind in those situations, or on these little side streets, you can just have res right on the street.
That makes a lot more sense to me.
Because we have res on Baldwin on the second floor.
Yeah,
that's
but that's
above.
above.
That's
Right.
above.
And then the place where it doesn't work is, of course, Montecito, but
That's different.
Nothing works on that.
doesn't
Okay,
matter.
so then that's really a zoning change that would address those two
But
or
that
three
could be
instances.
solved by that problem.
Okay.
So then it's not a non-conform, I mean, it doesn't.
Yeah, I don't think we need.
Should expansion or alteration of non-conforming, non-residential uses be allowed? Expansion or alteration of non-conforming, non-residential uses be allowed?
Depends.
Yeah, that's a,
Well, that's the
Right, do you want
proverbial
prohibit it
cafe, right?
outright, or, yeah,
Yeah,
that's an
The
example.
cafe example.
Yeah.
I
I think
think,
that's a
I think
depends.
the general rule on this is no, but we probably have so few of them that we might as well just take a look.
Yeah, I mean, I think,
So you would consider it with a permit?
well,
Yeah, I
let's say you have.
well, a
let's say you
review
wanna- let's
of
say
some
you
kind.
wanna double the size of your restaurant into the next storefront over. And it's current, and that
And I
storefront
have
over is
seen that.
currently.
Mhm.
Yeah,
that
I've seen that
storefront over
happen.
Is currently a account.
Yeah, but
Okay.
that's allowed. That's allowed in, I mean, that only happens if you want to double Mary's, because Mary's is the only restaurant that's not in a restaurant zone.
But what if the use is already too intense or something, you know? What if there's something non-conforming about how it's being used? I don't know what it is.
The
Oh, what
restaurant.
if it's a
Right.
liquor store
Mm.
Yeah,
and he wants to expand into the next,
mm-hmm.
Then I'd want to see that.
And I've seen that
But the
happen.
thing is, the liquor store, you're going to require CUP anyhow. So. I think any liquor you see, you just CUP, and we'd want to see that.
but, okay, then let's think about it, one that doesn't.
Yeah.
Just for,
okay?
That's
And I don't
not,
know,
that's
it's
not
hard for me
a
to know what's non-conforming, you know, what would be the example of
use.
that?
Well, we want to see, it sounds like we want to see it, because we don't know.
I mean,
Yeah,
I
would say
can't imagine one of
depends is
these,
my answer, so yes.
e-
It probably needs
except
some
in
review.
Montecito. And, you know, eventually we'll fix Montecito, but before we fix Montecito, if one of these comes up, it's such a mess up, we should just have them come here and we'll work it out.
Okay?
Well, I mean, what if it's this case about they don't have enough parking? They're non-conforming because they don't have enough parking, right?
Or the
then they
use.
could
And they
not.
want to
Then they could
ex-
not, because they'd be violating. I mean, we
They
wouldn't
want
just
to
say, well, you're not
expand
conforming, that's
in-
fine.
I mean, that's
They
what you're
wouldn't be
saying,
able to
should
do it.
expansion
Wouldn't
be
be able to
allowed? They
do it.
wanna,
But that's not a non-conforming use, that's just, they don't comply with code.
Yeah, it has to be a use incompatibility, right? So,
Well, it's
use
non-conforming
is
use
expanding.
because it doesn't provide the conforming the required
right,
parking.
it's not conforming because they
In
don't
that-
have
in
enough
that sense, we
parking,
do
so
look at it as
there's
being
a
non-conforming.
non-conformance
It doesn't
going
conform
on.
with code, or it doesn't.
It doesn't conform with the code and they wanna,
but the use is
But that's not a
That's,
non-conforming
yeah,
use.
that's not a legal non-conforming use
use.
issue.
No, that's
That's just, we
Yeah.
want to do this thing with our property.
And you're not allowed.
We need so many parking
many
places,
parking.
we don't have enough.
That's,
Well, you
that's
can't.
one of those
Yeah.
nasty parking issues.
well.
again.
That's yeah. I mean, that's
Right.
like the
That's not a-
restaurant, which is a conforming use,
Mm-hmm.
and they want to expand to the
but
next
it's not
storefront.
conforming
but-
because,
They wouldn't be able to provide the adequate parking.
Right.
Well, there's still a conforming use, but
And
still. a
and I
conforming
think
use.
the way we deal with
But
that
then
is,
it-
when we talk about the issues of reuse or change of use in existing spaces, up to a certain level, we just say we don't care about the parking.
Mhm.
Because it's just, you know, if it's 1,000 square feet, it doesn't matter if a Pilates studio requires
Yeah,
one
that's-
space more than. And at a certain level, maybe we have some size that has a minor review, and then above a certain size, we say, come to us and we'll look at it.
Right.
And so
But-
if that restaurant wants to expand, but they're missing 5 parking spaces, you know, I think that's something we want to see.
But like in this case, should expansion or alteration of non-conforming, non-residential uses be allowed? So that's
I think
really
the
about
answer
the
is
use.
We actually want to see it.
Yeah, because
I think we wanna see it.
I think the answer is we don't know what that is.
We don't know.
We don't know what it
We
is.
don't know, so we need to see it.
Let's just see.
Right.
Or
Well,
you can
yeah,
always
well-
include it in the code, in case you
Yeah.
do at some point come across this, so that there is some guidance in terms of how to respond to it.
Yeah.
It wouldn't hurt to have it in the code.
No,
In
no,
other
no.
words-
No,
We're
that's
saying
what, that's what we're saying,
we
is
have
that
it, but
we
need
can't
to-
think of a good example of how that works, so we wanna see it.
we need
Because
to see the
Oh,
project.
you want to
want
see
it
the
to come-
project.
we wanna see the project, because we
We're
want,
not saying we don't allow it
Okay.
or allow it. We
Okay.
kind of
Because
need
we
to.
don't know what.
we can't imagine how that works, but we know that it could happen, so we wanna be able to have control over
I
it.
mean, you could
Right,
imagine this in,
yeah.
you know, in Pasadena where there's a, you know, a mechanic shop where they're not allowed now or something, or, you know,
Well, an example would be like the little cafe that's just, you know, for whatever reason, it's non-conforming. I don't know how it could be, but it's a non-conforming use, but, you know, it's been tolerated. And one example of, well, are we gonna let them increase that non-conforming use? Let's say now they wanna put a commercial kitchen in there, but the only thing that they, you know, but they couldn't do that, then that's an issue. Are you gonna let them increase it? Or it's a little cafe, but like I said, they wanna push out their service area onto the back patio or onto the front patio. Are we gonna let them do that? Like, because that's technically increasing legal non-conforming use.
Right, I can think of another one that might happen. We have churches that own retail property and operate institutional uses in commercial space. Okay?
Correct.
And if they wanted to expand that, because remember, we're thinking res and commercial, but
Yeah.
it's all zones, right?
Yeah.
So that's something that I would want to look at.
Mm-hmm. Okay, next page. Use listed as a conditional use. Use listed as a conditional use. If a use that requires a CUP, but that does not have, whew, Jesus, how does it? All right, take 2. Use listed as a conditional use. If a use, if a use that requires a CUP, but that does not have one, vacates and is replaced by the same use, should the replacement require a CUP?
Okay, so this was.
Okay,
This was
we-
the
we've talked,
original
yeah, this is where we
question that
started.
triggered the whole use thing.
If not, should there be a time limit for the vacation beyond which the CUP would be triggered?
No, I'm just gonna shoot myself.
Well, no,
I-
so
No, this is
like
where
the-
we started.
This
This
where
is
we
like,
started.
you
There's
know,
a restaurant that
it's
didn't
7
have a
o'clock.
CUP originally,
And I think
then
this
it
is-
vacates.
This is 2 years.
I agree.
Yeah.
Because there's, you know, our record keeping is fabulous, so I'm sure there's ones that maybe they did, maybe they didn't, no one knows, and I don't think we need to, you know, if people are used to it, it's
So
fine.
after the 2 years, that use, that would require a CUP.
Yeah.
If
For
it,
that use.
so it would have required a CUP, but it didn't have one. They want to replace it with the same thing. After 2 years, we would say, yeah, we want to see a CUP.
But within 2 years, they would be able to without getting a CUP.
Yeah, so if it closed and reopened, you know,
Which
in
happens often.
14 months,
Right.
they'd be okay.
So you could have a whole series
Name a
of them
few
as
spots.
long as it's not gone for 2 months, 2 years.
Okay.
It's
That could be an
happened,
accounting reason, you know.
It happened like
It's
3
happened.
times in the last 4 months, so.
Well, it's happened.
Legal non-conforming uses discontinued. Should they be allowed to be restated with certain time periods? Reinstated with, all right, so legal non-conforming use discontinued. So it's a legal use, a legal non-conforming use that's discontinued.
Right.
Should they be allowed to be reinstated
What's the
within?
difference between this and vacating it, like discontinuing?
It's the same issue.
It's the same issues.
Same thing, right?
Yeah.
Different
Vacating.
ways of,
Yeah.
because one of it is, you know, there's the voluntary, there's the involuntary, and
it matters.
I don't think it matters on this. I think that,
Either it's gone.
I think
or-
this would
either
follow
it's
this,
there or
it
it's
would be
not
the
there.
2-year thing, right?
yeah, I
Yeah.
don't think so.
If
Okay.
it falls
Y'all are
within.
good
the-
on the 2 years? Or do you want shorter, like,
Well, I mean, conceptually, I think we should put it out, we should be longer, if we're trying to maintain or, not encourage, but maintain the non-conforming uses, you know. If we're trying to eliminate them, then you want to shrink that period, but I think we're of the mind that
Well, it's a
we wanna
take-
allow
well,
some
it
leeway.
can take a while.
Yeah.
I mean, let's say,
Yeah.
especially, think about during the recession, right?
Yeah.
The places were empty. They could have been empty. Some of those places were empty a long time.
Yeah.
Right.
The place where the optometrist is going in,
Yeah.
that was empty for
Couple of years, I
a
think.
couple of years.
Mhm.
So it could be, and when times are bad, those places
Yeah.
could be empty for a
The
long
other
time.
thing
Two
about
seems far enough.
restaurants is there's, a
Sure.
lot of permitting issues.
Yeah.
That just, even if there's no economic interim, there can be a vacancy for compliance stuff.
All right.
2 years seems good.
Consider whether the expansion of a single-family residential structure where the residential use has been rendered non-conforming may be allowed as long as the expansion of the structure conforms to current code. Note, this would mean expansion of a non-conforming use also. How do you think of these things? Examples in the city properties.
The counter and ask.
220 South Lima, okay, we just talked, in 40 North, okay, we've already done these.
Talked
We
about.
figured out how to fix this.
All right, so this is done.
So the answer is yes, you could expand that building physically then.
As
This
long
is a
as
different
it-
issue. This is an actual expansion of the structure.
As
but
long as it
we're gonna- we
matches
talked
the
about
current
that.
code.
Yeah.
That's
okay
what
with
you,
that.
that's what you
Current
asked,
building
right?
code.
Because we're gonna work on the use in the commercial zone, so
It's a
that,
zoning
so
issue.
that's an allowed use.
Okay.
Yeah.
No, but that,
Place
this,
has
this,
to-
this is asking about
Can they make the house
physical,
bigger?
the structure, not the use. It's,
Right. So
Well,
it's,
the-
by-
the-
by
the
default it
expansion
is.
of- Right, the expansion of the structure will allow expansion of a non-conforming
well,
use.
by default, yes.
Yeah.
But
But-
are you really getting at, are we okay with expanding
A building,
the
As a-
building?
as opposed to
knowing
intensity
that
of
it
use.
expands the
The
use,
use.
but it also, but it's being expanded
According to
to,
code.
to current conformance of the
right.
code.
Right, I think
it's
what that
fine.
literally means is
You make the
if
house
the
bigger.
current code required a conditional use permit to, let's say that they wanted to expand it by putting a second story on, and our current code requires a conditional use permit
They'd
for
have
this
to
thing.
get a-
They're gonna have to get the conditional use permit.
Yes, absolutely.
I
But
think
in
that's what that
concept,
means.
I think we'd be okay with it because
Yeah.
by default, they are complying with the current code for whatever they're trying to do,
Correct,
Yeah.
right?
right.
Yeah, we don't have a problem here.
I mean,
Yeah.
this isn't about we're assuming the structure is compliant, but the use is not.
Not,
No,
well, not
that's
necessarily.
it could
like
be the
East
structure.
No,
Montecito,
it might
for
have been
example,
too big for the
is-
lot
yeah.
at the
Yeah.
time.
It
there
may
could
not be compliant with the setback or square footage.
Yeah, could
So-
be in the wrong location on the lot, and now they wanna put a second story on.
Well, it should be the
Which
same question as we
is-
had before.
Yeah.
We were talking about this, right?
No, but there's a caveat. The difference is whatever they want to do to this non-conforming thing, they want to do it to meet
conforming
current,
way.
yeah, to conform to current code.
Like the lady that
which
put
would
the
be like-
elevator in on East Montecito. Her mom was moving into the house and she put the elevator in.
That's been a while.
Oh, yeah, you were around. It's at almost to the end of the block on the south side.
I don't see why we would have a problem with this because
That's the one
we're,
that
it's not like they're
parking
trying
lot
to
alley.
increase
Mhm.
the non-conformance. They're trying to, whatever they're trying to do, they're trying to be within code.
As long as it
Thanks.
doesn't increase the nonconformity, I don't have a problem with that at all.
Okay, I think we're all in agreement. All right, next one. Non-conforming parking in the commercial and manufacturing zones. Consider codifying the current policy to allow non-conforming parking to be grandfathered in and used as a credit towards the parking requirements for a new use, regardless of when the previous use was vacated.
This is that issue that we talked about,
Yeah,
how we,
but
this
I-
policy.
I guess the only caveat I have on this is regardless of when the previous use was vacated. Because if it's gone through, 5 different uses, that encourages somebody to go hunt back for the really intense use in 1955, and I don't want to do that.
Car dealership.
Yeah.
Yeah.
Oh, no, we typically, the way we work this is that we use the last use.
Last
Even if it was, say, 5 years ago and it's been vacant for 5 years. We'd
Oh,
still use
okay.
the last one.
Last
We
use,
don't try to
not
dig up.
previous uses before
We
the
wouldn't
last.
even know, I mean, yeah.
Yeah, the last use.
But is there a limitation there? After
I'm just-
3
I
years,
mean, I
is it
think the-
over and
the
done
issue
with,
to
or?
me
Uh-huh.
is this. Let's say you have two storefronts next door to each other in the same building, right? One has had a more intensive use and has more credit for parking than the one next to it,
Mhm.
right? And now they're gonna have the same current use. Say they're both gonna be restaurants. Well, this person is credited with 10 spaces, and this one is credited with 1 space.
Mhm.
Well, that's just so unfair. It's so unfair. Because why should the person who's in there now, one person who's in there now, be allowed to, be credited with more space than the other person, depending on what happened in the past?
Mhm.
I just think to me, that's an issue. It's kind of crazy.
Well, they're two different properties though, right?
Well, let's say they're right next to each other, 2 storefronts in one building. This could happen,
Well, in a lot of ways,
Well, it could be like the optometrist, isn't it like two?
yeah, like
technically
that.
two storefronts?
Mhm.
But they were previously occupied by one use.
I know.
Yeah,
So then in that case.
but I mean,
Yeah,
it
but
it could be, like on Kirsting Court, say. There are 2 little places, one has credited with more than the other.
that's why I think that
I think that's
for
like, it could be a very unjust situation.
for existing small spaces, and we need to figure out what small means.
Yeah.
I just think if it's downtown, we don't even worry about the parking, because it had parking of some type
Right,
at some
yeah.
point, and we've got a big parking lot,
And there's some parking on the street that everyone is sharing.
and if it's
There's not that many places except sort of on over here.
Well,
on
we should
Baldwin,
start
there's some
moving down
parking
this way,
behind.
too.
But if you're looking down this way or, around Kirsting Court, there's no parking for those places.
No, I mean further down.
Yeah, but down there, it's sort of the same thing. I'm just like, the way it is now is a crazy thing.
right, and
I
if
think
it's
it should be something different.
if it's 900 square feet, it doesn't matter if it's an office or a Pilates or a restaurant or anything. As far as parking goes, it's just it's not that big of a deal. If somebody goes onto the Howie's property and demos that building and builds, a big multi-story whatever, yeah, we need to deal with that.
Mhm.
But if
But
somebody's
this churning of places, they churn all the time, and it's I think a waste of time and effort, and could lead to injustice that some people get credited with more, some people get credited with less, and they
So-
get dinged for something that isn't
Mhm.
relevant in any way, shape, or form.
So if we were to like codify this, that is a potential possibility that there could be an inequity in what you're grandfathered with in parking because of the use.
So is
That
the,
could
Because
happen,
the
right?
current, the past, the
so
recent use.
the grandfathering is the problem. In other words, that they get to carry their
Well,
reserved spots with them, as opposed to everything resets when
Yeah.
it changes?
well, I don't know that it's a problem. It's actually a way to try to solve the problem of not being able to provide more parking, therefore being limited to what use you can
And I think
allow.
the real fix
It's
of this
been the
is
way
changing the
to-
parking rule, not changing the conformity.
no, I agree. I think
Yeah.
I think this one's a no-brainer.
Mhm.
I think there's other parking issues, and I think what we should do now to try to deal with this is to say reuse of existing spaces under a certain amount, the credit equals whatever the requirement is. You're just done.
There you go.
you don't need to provide any
Yeah.
new parking, and then
Once it gets
Up-
over that size.
once it gets over that, we'll review it.
Mhm.
And maybe there's, I know there's in the parking, there's the parking studies and parking share and all that kind of stuff. We can review then, and maybe we'll give you some credits or whatever. And maybe some point we'll actually do a more comprehensive parking review. But when you're talking about 1,000 square foot storefront, it just doesn't matter.
I agree.
I agree
If
too.
you're talking about, what's the name of the restaurant now over towards Lima?
Nanos.
Nanos.
Mhm.
That's a pretty big restaurant space, right? That one, I think that it makes sense to credit that because it's a restaurant. And if it changes to another restaurant, I don't know what they're parking.
Well, that one has a lot of parking.
Well, they share parking
Available
too,
in the-
right?
They have a lot of parking
It's
room
been a lot of
behind.
different restaurants.
Right.
That one doesn't need a credit.
Oh, there's so many restaurants.
So,
Since I lived here.
but I mean, that
Almost
kind of
can't be anything
use,
else,
that's
I mean.
pretty big. If that one, well, let's say if Arnold's wanted to switch to a restaurant, right? Then we need to look at that, because that's a big space and it's also far away. But you got these 1,000 square foot things, we just don't need to futz about that, because whatever the use is, it's not gonna really cause that much problem.
So at this point, we don't include anything in the non-conforming, because it's really an issue more of the parking, and you can address that later. Is that what I'm hearing?
I think we should do both, because I think, I don't think this hurts anything. I think it's helpful.
Yeah, I
Um,
just think that we should,
But I think
Right.
we do a little bit more on the parking, and I think we can without doing a full-scale review. of the
Because
parking.
this would cover like the nanos and stuff like that.
Right.
But the stuff in downtown, I think would be better served covered by the parking changing
yeah.
than trying to capture it here.
Okay, the last one, include section on non-conforming lots. We talked about that.
Right.
I don't think
Well,
we
isn't
need-
there another section where where the lots are under subdivision or something?
Subdivision,
Yeah.
Does it need to be in here?
Not necessarily.
I don't think so. Because
Okay.
Pasadena has a whole section on it, and it's really not useful.
It's not useful. I just think it doesn't,
It's just kind of stating what the law is regarding
don't think this is
subdivision
important to
requirements,
us.
so.
I don't think so.
So we made it to the end of the list. And we talked about setting up a subcommittee that would begin to, I don't know, fill in, I envision a matrix that involves the use, the size, something about intensity, and the kinds of permitting that each one would require, as opposed to right now, it's a CUP or it's a permit,
Yeah.
no matter what it is, no matter what size.
Right.
And I think, is that something that you're looking for back from the subcommittee, or do you recommend, or?
I think the subcommittee should do it, because then the subcommittee can bring back the revised commercial code with those matrices even.
Mm-hmm.
But I think reviewing that, the full commission should, verify and make sure that we like where the different things are. But once you get it laid out, I think it's easy to go through and.
What do you think?
But
How many
are
people
this,
can we have in a subcommittee right now?
Three.
Can we have 3? Because we have,
Right, yeah,
quorum is 4,
right.
so we could have
You have
3.
to have, yeah, that's right.
I asked that earlier. I
Oh.
was wondering that.
It's just like
The subcommittee of 4. Poor Bill.
this is like a subcommittee.
Leslie's, technically, we only have 6 planning commission members right now, correct?
We have 5 planning
Well,
commission
no.
members.
No, that's what I'm
Bill.
saying, is because she resigned,
Oh,
we
yeah.
only got 6.
No, we only have
Well, we have
5.
We have
Yeah,
5
we're
existing?
replacing-
Oh.
We're missing 2 members.
Oh. Okay, well then.
We're
in
an
that
endangered
case, a
species.
Yeah,
What's a
if you've
quorum?
only got 5, a quorum is 3.
Right,
So you can have
only
a
have 2.
subcommittee of 2.
yeah.
That.
So paper, rock, scissors?
Well, let's talk about this. Is the subcommittee looking at those issues you just stated, or also taking over the entire non-conformance code section and then
We could have 2
redoing that? Like,
subcommittees.
are we
Two,
leaving
that's-
that and then, because you had said earlier, like, it doesn't make sense to plug in.
No, I think we should just take the whole non-conforming use code and the whole commercial code and revise based on our discussions.
Based on our discussions tonight.
Yeah.
Okay. And then what's the subcommittee doing?
What?
What's the
They're-
subcommittee
That's
doing?
what they're doing.
Yeah.
That's what
the
they're doing?
subcommittee does.
Oh.
And then brings it back, and then I think we can review, especially the matrix, and then maybe in September we'll get some more members. We could, if we want to, we could plug another person into the
There you go.
subcommittee.
Is there enough, what's going on? Yeah. Is there any future in having another member or 2? Is there any?
So the direction that I received has changed. Apparently, council would like to receive 4 applications to be able to fill the 2 spots concurrently.
So we need 1 more
We
application?
need 1 more.
Need a stalking horse.
See if I can find someone to apply, right?
Well, we have 3 applicants now, and at least from what I could see online of their applications,
And
they
they're
all
unwilling
seem-
to like
they all
fill
seem
one
good.
and
Mhm.
they want to fill both at the same time.
Right.
Can we like beg them to fill one?
Now he's
We could
broached
try.
that with the city manager, and he can talk to council.
Yeah.
That's worth a
Because
shot.
I think we really need another member.
Well, I think we I mean, I could understand if we had 3 applications that were all, you know, and we'd like come with, let's wait till we get, but it seems like we have 3 good applicants. And we've already gonna have 1 good applicant who we're gonna say sorry to. This whole concept of having lots of applicants for a few means you necessarily gonna say that some people don't get a serve who are volunteered. I don't know.
I mean, personally on the subcommittee thing, I think 2's fine, but it actually works better with just the recent experience. I think having 3 members, because there's something about bouncing those.
Yeah.
I mean, you're
And
kind of
also about having an
triangulating.
odd number to decide ties.
Yeah, well, to
I would be
triangulate
happy to
the
be on the committee
concept.
if we can have 3, when we are able to have 3
When you were able to
people.
have
When
3. See,
we
the
were able-
problem,
Yes, yeah.
problem
I'm not
is
saying
that-
if,
yeah.
I'm saying when we're able to have
When,
3
yeah.
people, I would be.
I'd be happy to serve on the committee as well.
I
So,
would too.
you know, I think it'd be a interesting project. But, perhaps then we should wait, should we table this until we get?
That's what I was getting at.
that's up to you all.
But the problem is, if the council decides to wait until they get another applicant, we might not get more people until October.
Yeah. That's realistic.
Mm.
The other thing we could do is we could have the skinny subcommittee do the first cut and bring it back to the whole commission instead of like, I mean, before what we did is we had the subcommittee sort of like.
Weigh everyone to decide who gets on.
Well,
No, we are not doing that. But you know, we had the subcommittee sort of do it all up until it was done and then bring it back. And we could do it sort of more iteratively where the subcommittee does the first cut and then we sort of chew through it and then
Yeah.
So
that
you-
way we get more participation.
So you'd see them as editing out the Pasadena ordinance, the parts of Pasadena that don't apply to Sierra Madre, and then looking at the table for
Commercial.
commercial uses?
Yeah. Yeah, and fixing the mixed use issue. That'll fix the res.
Those 2 properties.
Well, also, it helps deal with the mixed use issue, which is sort of not really that much to deal with the nonconformance at all, but it's an issue in the commercial code that we might as well fix if we're doing it. And
I mean,
that's
yeah.
and that's not a big deal. That's pretty easy.
I could sign off on that. Like if we did chunks of it and then brought it back here so that we can all kind of, you know, if it's fully baked and we bring it back, then it's kind of like, that doesn't make sense. But I think if, you
Or
know,
if it's an edit, in other words, if you just strike out the parts in the Pasadena that doesn't apply to Sierra Madre and put in general language that we just kicked around and then looked at that matrix.
those would be 2 things we could.
I think we could just, I don't know, to me, it's just easier just to do the whole thing. Just do it all and then bring it back. And because to me, once you, at least for me, it's easier just to see the whole thing, see how it all fits together. And then focus in on the parts we want to focus in, which are going to be that matrix, I think. I think, you know, there's like some flowery language on some of these things and dealing with some of the Pasadena stuff. But mostly, I think we're going to want to, as a commission, we're going to want to take a look at the matrix and say, does this one make sense here? Should we move this one up or down? And we're going to have a lot of different factors, too, because you have whether you want use review, whether you want design review, and whether you want that on existing buildings or new buildings, and then potentially 3 different size levels, right? You're going to have smalls permitted, minor, and then full. So that's what? 12 different options.
I need a chalkboard.
And so to me that, you know, I think having that matrix like actually built, and then it would be easy to go down and just say, let's move this one over to this box. And
Yeah.
See, I saw it as a list and then check marks based on if it's a certain size, then it needs this. You know, what kind of review it gets based on what it is. How is it being used? What's happening? In other words, you could have a yoga studio that is small, 1,000 feet, or you could have a yoga studio that is large.
I think it's the same thing he's saying.
Two different.
Yeah, it's just sort of how you envision it, and that's why it'd be actually handy to have the dang chart in front of you.
Right, exactly, okay.
Because then instead of arguing about the lines, we could just do it.
Well, I mean, so here's the question. We can do it that way and get going, or we, wait around until
So-
we can get a committee of 3,
So,
which,
do 2 people want to start on that and then wait for the city council to expand our numbers so that we can pick up a 3rd person?
Mm.
Is
Yeah, I
that,
mean,
You can
I'd
do
be-
that.
I would be willing to start with John working on
Okay.
this. After I
Yeah.
get back from.
the fact that you're willing and the fact that, you both have the skill sets to do that, it can't hurt. There's nothing
The
that.
worst thing that could happen is we
We
waste
could
our
throw it
time.
out. We could throw it out.
I don't think so, because whatever it is you're gonna find, we're gonna have to.
well, Bob,
know,
we
choose
want to
from-
reserve the right to be able to throw it out.
Right,
Yeah.
okay, fine.
Yeah, you should.
Is staff okay with that?
Yes, absolutely.
All right, so
That's a good idea.
it's formed. Do we need a
Do we need,
Does
so
it
what do we
need
need to? can we
motion,
just-
or is that good?
We don't need to vote on that?
You
We're
don't need to vote on it.
As an
um,
internal,
Yeah. You can, just by consensus, and you're the chair, you can say, I want to appoint a subcommittee.
Okay.
Any volunteers?
the subcommittee has been volunteered, and they are, and so appointed.
So, as far as the commission's concerned, this is gonna get tabled till they you guys churn through
We
it.
come back.
So you're ready to.
And it'll only be 2 until the planning commission is of a certain size that we can
Yeah.
have 3.
That's
So-
right. You can't have 3 members on the subcommittee until you're back to 7.
And so if
Oh,
the subcommittee has questions that they'd like to ask of other members,
Mm-hmm.
really, we have to wait until we have a full meeting.
You do, yeah. I mean, for perfect compliance with the Brown Act, yes. I'm trying to think of
So
of an exception to that.
I'm just thinking of if like, let's say we're chugging along and we're mostly done, but we say, okay, we've got these 3 or 4 issues.
Right.
Then we should talk to Vincent and say, can we schedule another discussion item so that we can chew through these?
I think that's right, as opposed to, gee, I want to call a different member to see if they remember this the same way I remember it. That's different. That's
We
just,
can ask staff those questions.
you could,
Because
yeah.
staff remember
that's
that the
true.
way we remember it.
Would it be worthwhile to add in our agenda, subcommittee report, and make that part of ongoing agendas so that we don't have to bend over for special scheduling?
We could do that, just add a
That way,
subcommittee
that way
report
you could,
section
Well,
and
but could we?
you would always
could
have that
sub-
option?
Yeah.
Because one of the things I'm thinking of is like, say we come into some design issues that we'd really like to talk to an architect about, or health and safety issues that we'd really like to talk to,
Yeah,
It-
we gotta wait.
Could we ask those questions in that report item?
Oh, you mean that's coming to the,
If we put it on the commission. on a
sure,
regular-
yeah,
Okay.
because that's coming back to the commission anyway.
Right.
Okay,
Yeah,
then that's
definitely.
good.
Yeah, so we'll have an agenda slot that we will turn to you and say, how's it going? And you can ask your questions and we can solve your problems. And that'll be a standing item on the agenda, okay.
That seems fair.
Okay, that was cool. This was a great discussion. This was a lot of fun, actually.
You have officially achieved planning nerd status.
I like that. So, once again, we have an opportunity for oral communication, and we don't see anyone from the public, so we will go, anyone on the planning commission?
I'd like to make a statement about something that has nothing really to do with the planning commission, other than being part of local government operations. Which is that, as we all know, this innocent woman, Heather Heyer, was killed in Virginia this week by Nazis. People who would believe that a person like me is not qualified to serve in any government form and would be better off dead. And I just think that we need to remember that We need to be accepting of other people and supportive of everyone's rights in the community.
Yeah. Actually, one of the things we like about Sierra Madre is its tolerance and acceptance.
Mm-hmm. And I just think that's not true everywhere, and we don't have leadership in this country that's encouraging that, and I think it's really important.
In Sierra Madre, a wonderful example of that is that the people in Climb are coming all over, and this is a safe community, an accepting community, and we embrace everyone.
Mm-hmm.
And it's great.
Let's keep doing that.
Yep. Anything else? No? Staff?
Just wanted to announce that the next Planning Commission of September 7th, we are going to be canceling that meeting.
Okay.
And that's it.
Maybe by the time we get back, we'll have another commissioner. That'd be nice.
Dream on.
Okay, and then meeting is adjourned.